before the Honorable Justice, the Appeals Court, now sitting in Boston, far and within the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. With me on the panel for all 6 cases that we'll be hearing this morning on the video monitor is Justice Walsh, participating remotely in a hybrid fashion. To my left and your right is Justice Paul Smyth. As I say, we will be the panel for all 6 cases on the hearing list. I apologize for the delay in the start of our session. We had some technical difficulties. Technology is wonderful when it works, but occasionally we encounter these challenges. We will hear the first 3 cases, the first two of which are criminal matters, the third of which is a civil matter, and then we will take a brief recess and resume with the remainder of the list. 1 criminal matter and 2 civil matters. We are familiar with the arguments that you've made in your briefs, with the procedural and factual background. You needn't repeat all of that for us. You will have 15 minutes on each side of the V. If any case, if there's more than one person arguing on either side of the V in any case, please let us know ahead of time how you'll be dividing your time, and there is no rebuttal. The monitor, or the video counter, the digital counter timer on the podium will tell you the amount of time that you have left. The light will turn from green to yellow with 1.5 minutes remaining on your time. And when you reach the end of your time, the light will turn unmistakably red and flash. That means that your argument has come to an end unless the panel has further questions for you. If you reach the end of your time before you reach the end of your argument, you may rest on your brief for whatever remains, and if you reach the end of your argument before you reach the end of your time, you needn't continue speaking to us. With that, I'll call the first case, case number 2022 P948, the Commonwealth versus Juan Carlos Felix.
Morning, Your Honors. Matthew Malm for Mr. Felix. So I start, Your Honors, by stating that, so this is a Rule 36 case. The Commonwealth has to justify 559 days. I will note that I said 560 in my brief. Commonwealth said 559. I recalculated. I was off by a day. So we're in agreement on the amount of days that need to be justified. My plan is to just go through section by section. Obviously, some sections will take less time than others, but that's my plan. So the first period is included. That included the arraignment, pretrial conference, compliance hearing. These are all straightforward applications of Graham, scheduled for the first time, so those are all included. In this period also, I included the discovery hearing, which was scheduled for September 20th, 2017. That was triggered by the filing of a discovery motion. It was a discovery motion for mandatory discovery. So under Commonwealth v. Taylor, that would also be included as well.
Included without any objection. The case law is pretty clear that acquiescence, the time wouldn't be included. And
yes, Your Honor. So in Taylor does put the burden, so Taylor lays out kind of what needs to be done in cases where mandatory discovery is an issue. And so as long as the defendant files a motion for the discovery to compel or a motion for sanctions, which was done in this case, it's up to the motion judge to determine, at that point it's up to the motion judge to determine if it should be told. The default position is that it's included.
But the defendant has obligations. I mean, Laurie makes that clear, as well as some other cases. They're obligated to press for a speedy trial, or obligated, again, not to acquiesce. And is there any sign in that first time period that the defendant made any request or any objection to any delay or any request for a speedy trial?
No, and under Taylor, that's not required. So he filed the motion for the discovery. It was only seeking mandatory discovery, and under Taylor, that's all he needed to do. He's not going to be punished for not objecting to that setting of a discovery date.
So, counsel, let me jump in here. Can you hear me okay?
Yes, Your Honor.
Okay. So, I think you touched on it. I just want to make sure I'm clear. Do you agree with this statement that without objection, the typical continuances are excluded I'm hearing that your interpretation of Taylor is that you disagree with that statement.
Yeah, Taylor is in effect an exception to that general rule. I do agree that that is a general rule, yes.
Okay, so for me, and I don't want to speak for my other panel members, and I love cases like this because it's the one time that we can all be mathematicians, something that we all never wanted to do, right? But here we are. So I'm looking at the period of April 23rd, 2018 to June 4th. Included or excluded, then I'm looking at June 4th of 18 to July 30th. I'm looking at April 22nd, 19 to 10/15. And so for each of those three categories, I want to make sure I understand your argument, and your brief was excellent, but I want to make sure. Included or excluded? So again, 4/23/18 to 6/4, 6/4/18 to 7/30, and 4/22/19 to 10/15. Those, I want to make sure I'm clearly understanding the argument. Is it that the judge was incorrect in deciding that that wasn't going to count, or is it's just not good cause? What is it?
Yes, so I'll start with the first period you mentioned, April 23rd, 2018 to June 4th, 2018. That period is the first trial date was continued over the defendant's objection, and the reason for the reason the Commonwealth requested the continuance was because the ballistics report was outstanding. So then, and the judge in the transcript said, I'm allowing this mostly because lack of a witness. And in this case, DeRico, which I cite in my brief, sets out the standard for whether this should be included or excluded. And in DeRico it says that the Commonwealth would have to establish that trial could not reasonably have been held until the party obtained the testing result. And so our position is that they didn't need the ballistics report to make this case. It's not necessary. The gun was, and I'll just run through the facts in the case that make it not necessary. Officers observed two people matching the description of the two suspects in the area who ran on his approach. Officers saw the defendant hide under a porch. The officer later searched that area and found the gun there. The gun it was a revolver. It contained 1 live round and 3 spent casings. There's also a witness who testified that he saw that the weapon was fired. So there's
The judge made a finding that good cause supported the continuance, right?
Yes, Your Honor.
What is our standard for review?
So the standard of review is laid out in Commonwealth v. Weed. And for Rule 36, when you're looking at a Rule 36...
I'm talking about the judge's finding that good cause supported the continuance. And we evaluate that determination by the trial judge under abuse of discretion, error of law, de novo. What is your position on that?
So my position is that Weed controls, and Weed lays out that when you're looking at...
Just tell me what it says.
Yeah, it says...
In your view.
It says, so when there's no testimony, there's like no live witness testimony, when you're looking at the record, it's all in the record, there's no live witness testimony, then it's de novo.
So we extend no deference to the judge's finding on that question, and you suggest that the judge was wrong, and we should find that on the same record that good cause did not support that continuance.
Yeah, you could look at it without, yes, Your Honor, without deference, and I suggest that there was not good cause relying on DeRico and the facts of the case, yes. Yeah. And so, I'm sorry, Justice Walsh, what was the second period you?
Thank you, counsel. So the second period is June 4th, 2018 to July 30th, 2018. And just, I'll put myself on mute just so I can hear you better. Next one is April 22nd, 2019 to October 15th, 2019. I just want to make sure what your position is.
Understood, Your Honor. So that June 4th, 2018 to July 30th, 2018, it's essentially same exact argument as the previous section we just talked about because it's all the same reasoning. Again, the ballistics report was unavailable. Again, the defendant objected.
So in essence, this case comes down to the question whether the ballistics report was an essential element of the case.
Yes, and I think, and also in the section I'm about to get into, that final section that Judge Walsh pointed out, it's also, again, another unavailable witness kind of issue, and in that one, it's, whether these three officers were there, two officers weren't, and the question is whether those were, essential witnesses. And with regard to that section, April 22nd, 2019 to October 15th, 2019, I think the notes to Rule 36 kind of lay out the Commonwealth's burden, when they're coming before the court and saying, oh, we're not ready, we don't have a witness. And it states that they should set forth with particularity the reasons why a continuance will enable him to obtain the witness and should state those facts as to which the witness is expected to testify. That didn't happen here. The other important language in those notes is that they state it will enable the court to make the necessary determination on the facts presented whether the unavailable witness is so essential as to warrant a continuance. Here, we don't know who the officers were. We don't know what they would have testified to. There's some vague information regarding the defendant's medical condition, and three other officers.
But didn't the ADA, first of all, the reason was the officer was injured, correct, he or she?
Yes.
And didn't the ADA, I don't remember the exact word, but say he or she was a necessary witness?
Yes.
So is the judge not entitled to credit that experienced counsel's word that that's a necessary witness in this trial?
My position is no. I think pursuant to the language in Rule 36, which I think is important, and it would be good if this court, could make that clear to the lower courts, that they should set forth with particularity the reasons why a continuance will enable him to obtain the witness and should state those facts as to which the witness is. So the rules are expecting the person moving for a continuance based on this to give more, to flesh it out. And that's especially important in this case where this was the fourth trial date.
But
and it was objected to every time.
There are, trials are messy events, and it is typical for parties in a trial to offer evidence on particular elements of the case from multiple sources in case the evidence as produced at trial doesn't quite pan out the way they anticipated. So simply saying that they could have established this, that, or the other thing through a different witness does not render inessential an important evidentiary source from an alternative perspective, right?
So, the way I would respond to that is, firstly, they could clearly make and I understand you can present it from different.
There's not a scale that says, okay, now we've got enough and we can rest with confidence, right?
I know, and so I guess I would start by saying there's a case which admittedly is not cited in my brief. I came across it when I was preparing for oral argument, Commonwealth v. Lodge, and in it the court states, and it's an oft-quoted kind of philosophical underpinning of the criminal justice system. A defendant is entitled to a fair trial, not a perfect one. And I think that should apply equally to the Commonwealth. They're not entitled to a perfect trial.
No, but we're also not going to be directing judges to get their arms up to their elbows in determining how much of the case either side can put on. And one of the arguments that we hear quite frequently from the defense side is that they were deprived of an adequate opportunity to present their full case, either because of limitations of cross-examination or because of their inability to bring a witness forward. And we deal with that as well. I agree with you that it has to apply equally and fairly to both sides. But we're really not going to get judges into the business of dictating how much evidence a party is allowed to produce, except at the margins.
So, and I would respond to that, Your Honor. I think Rule 36, the drafters of that, I think they want exactly that, especially when there's a request for a continuance of a trial date that is being objected to. I think that certainly invites, a judge to weigh in.
Sure. but there's a balance, and they have to weigh the importance of that, of the missing evidence, against the prejudice or burden of the delay.
Yeah.
Quintessential
Counsel,
discretionary
can I-
call. Go ahead.
Can I jump in for one moment? And I'm still unclear, and I apologize if it is clear and it's just me, but are you appealing on those dates that I've indicated, the good cause determination, or are you arguing that no good cause determination was really made? Is it a little bit of both? Is it one or the other?
Well, I think it's not entirely clear from how the judge frames, his decision. I think the bottom line, though, is that you can affirm for anything that's on the record that you can find in the record. So I think that's to some extent somewhat irrelevant whether he exactly what he found. I think the bottom line is that good cause could not have been met. With respect to the ballistics report, because of how the facts came out of trial and could have come out of trial wasn't necessary. And then with respect to that last period, they simply didn't make their case for a continuance. I'm not seeing any more. If there's no more questions, I'll rest on my brief. Okay.
Thank you.
Thank you.
For the Commonwealth?
Good morning. May it please the Court. Danielle Borges on behalf of the Commonwealth. The Commonwealth would respectfully ask this Court to affirm the defendant's convictions. Briefly starting with the standard review, the Chief Justice was correct. The Berry case says that this Court will give deference to the trial court's decision, but may reach its own conclusions. If it's also easiest for the Court, I can also just go date by date, and then if there are any specific questions, I can.
The date by date is something that we will go through. We can look at those dates and do
Right.
the math. As despite Justice Walsh's disclaimer, we will. It's not complex math. It's arithmetic.
Sure.
But it seems to me that at the center of that arithmetic exercise is the foundational question of whether there was good cause, right?
Sure.
And so why don't we center the argument on those two elements of evidence?
Sure.
The ballistics report and the injured officer.
Sure. So regarding the ballistics report, as discussed, the Commonwealth would argue that the judge was correct in deciding that it was an essential element to the case that the Commonwealth had to prove, and therefore it was good faith basis for the request of the continuance, and he found that the interest of justice requires that the matter be continued. Again, as this,
Isn't preparation of the ballistics report something that is largely within the Commonwealth's control?
it's my understanding that the ballistics report, there was just delay in getting that, and so the Commonwealth didn't have it until August 28th, 2018.
I know that, but isn't it incumbent on the Commonwealth to take steps to try to expedite the preparation of that report if they've got a trial date looming?
Sure, and it is my understanding that the trial ADA was persistent in, requesting this ballistics report, but ultimately, as much as they asked, it wasn't received until that August date, and where it was an essential element to them proving that the firearm was operable, ultimately they decided that they couldn't move forward with trial until they had that. So then,
Is operability a live issue on the facts otherwise present in this case?
I believe there was testimony that the firearm was heard to be fired, but I still think that it was the Commonwealth's burden to prove that it was operable regardless.
I'm sorry, you lost me.
Well, is the question you're asking whether there was any debate over whether it was operable?
Right. I mean, if there was evidence that the firearm discharged, doesn't that rather conclusively establish operability?
I guess it would depend who was giving the testimony, and I think in this case, having the report that is indicative of this was a working firearm, the ballistics report. I just think that is stronger evidence that the Commonwealth was entitled to waiting for, instead of just relying on testimony that may or may not have been credited. Regarding then the 2 injured officers, I believe that was the next issue, which was then which dates was that? So then we're moving into April 2019. And again, I would say the argument still be that these were 2 essential witnesses, that the experienced trial counsel expressed that to the judge, and he found that it was a central issue and therefore continued it for good cause.
Counsel, this wasn't a very complicated case. Do you agree?
Yes.
And the fact is that it took nearly 3 years to try this defendant, who was in custody for a lengthy period. Mm-hmm. And I know the defendant pursued the Rule 36 and not the constitutional claim, but can you comment on, it seems from some aspect of regard that the letter of the law kind of undermines constitutional kind of underpinnings of the law, the defendant's right to a speedy trial. He raised his right clearly about a year after with his first objection, I'd say. And again, there weren't COVID delays. So can you speak to that generally, why a defendant is not entitled to a speedier trial under Rule 36?
In this case, it wasn't a complicated case, but it was, I would say, complicated in the sense of there were multiple indictments. There was an issue with an ACC charge, which worked its way out with the Commonwealth ended up dismissing an indictment, re-indicting the defendant, and then there was also a lengthy delay following the September 2018 date where the defendant defaulted on a pretrial conference. The court had to work its way through issuing the warrant, bringing the defendant in, removing the warrant, and then by that time...
How many days was the defendant in warrant status?
I believe it was 33 days, but then because of that delay, the court wasn't able to then schedule a final pretrial conference, a trial date, until the following April, and then the Commonwealth ran into the issues with the injured officers being out and then the injured chemist from the forensics report. So it ended up ultimately being a series of unfortunate events where the timing just kept falling into each other and extending the delay beyond what the Commonwealth had initially intended.
No, Commonwealth, I feel like I agree with Justice Smith's concern. I mean, anyone reading Rule 36 would see that there's a fundamental fairness of, especially when an individual is in custody, having a timely trial. And I agree with many things that you said, but this doesn't seem to be atypical. And I'm struggling, and help me with this struggle, that in your brief, in essence, you still think you have a third of the clock left. This is a case of 3 years before trial, defendants in custody, and when you do the mathematical arithmetic equations, it seems to me like you still think you've got a good 30, 40% of the clock that you could run and still fit within Rule 36 standards. And that makes me sit up and be concerned about the counting of the time here. So if you could address that just on a fundamental fairness, the problem for me.
Absolutely. The Commonwealth definitely understands that concern. And looking at the dates of time, when I was rereading some of the cases, it does seem like there is a bit of confusion on what dates could be includable and excludable. Specifically, I know the Commonwealth's calculations from the April 2017 arraignment to the September 2017 first discovery hearing, where the Commonwealth argued that the 112 days were excludable. It seems that they might have been includable. Regardless, even including that time against the Commonwealth's calculations, they still would have justified enough time to warrant the dismissal of the defendant's Rule 36 motion. The Commonwealth understands the concern, but I think in this case, as I stated before, it was when it came down to getting closer to trial date, there was just those series of events where the trial judges repeatedly found that the Commonwealth had good cause to file for a continuance, and they accepted that continuance. So in this case, while it definitely took longer than the Commonwealth would have hoped, the extensions were justified. Are there any further questions on any dates or anything?
Yes, on the specific point on the discovery motion, your brother cites Taylor for the proposition that certain time should be included, and your position is that time shouldn't be included because he acquiesced. Is the distinction that Taylor was a motion to compel discovery and this was a boilerplate motion for automatic discovery, or how do you reconcile the difference you have with your brother on that issue, or the interpretation of Taylor?
After reading Taylor further, and it might help for this to possibly be clarified by the court, but it does seem like where the defendant filed that mandatory motion and not a motion for discovery he wasn't entitled to, it might have been includable. So the Commonwealth's calculations on that might have been incorrect. And if that is the case, they would concede those 112 days. But I do think the difference being in Taylor, they were discussing the motion for discovery that they weren't entitled to, as opposed to here where it was a motion for mandatory discovery.
But just so I'm clear, your interpretation of Taylor is now consistent with counsel's, and for that first time period from April 4th until September 20th, in your brief you had 58 days includable, 112 days excludable. What is your position today?
After reading Taylor and reading Graham, the Commonwealth would be willing to concede that day period due to the fact that it was a motion for mandatory discovery. But that was confusing.
So add in the 112 days.
Correct. So even with that, this Commonwealth would have still justified 720 days, which would be over the period that they needed to justify. Any further questions? All right, the Commonwealth will rest on.
Seeing no further questions, that will conclude the argument in this case. The case is submitted. The next case on our hearing list is case number 2022 P387, the Commonwealth versus Scott D. Rodricks.
Good morning, Chief Justice Green, and may it please the court, David Nathanson for Scott Rodrigues. I just wanted to begin by thanking the court and the clerk's office for keeping the streams up post-pandemic, because it's good for the public, but also allows Mr. Rodrigues' mother to observe the proceedings today. So for today, I intend to focus on the Miranda issue and the closing argument issue. And I know the court's read the briefs, and I know the court is aware of the facts. I just want to hit maybe 40 seconds of factual context. I timed it out. And it's because the Commonwealth's evidence of malice in this case was so thin that any of these errors may have tipped the balance, and that's why I want to talk about it. The evidence was not overwhelming. It was hotly contested. The Commonwealth's evidence was of a brutal, extended beating of an unconscious man. The defense was that Mr. Cousineau fell and died from a fall, and a fall could have been from being drunk or from lunging at Rodrigues, or Rodrigues lunging at him, or tripping over a curb. So the case really turned on malice, and malice turned on two eyewitnesses who contradicted each other. One said only punching, the other one said only kicking. The surveillance video doesn't really show much. The Commonwealth admits that. And the evidence was that at least some of Cousineau's injuries were consistent with a fall and medical treatment, and there's no injuries to Rodrigues' hands. So that's the context that I think is important. The trial judge observed during trial that this case wasn't a slam dunk for anybody, and the jury rejected murder one. So
he said that at a sidebar before the first witness had even finished testifying, correct?
Yes, Judge Dupuy said that, yes.
He hadn't heard from the identification witnesses at that point.
She had not heard from the...
She had not.
She was in...
Thank you.
Yes, that's correct. So with that context in mind, the Miranda issue, the questioning of Mr. Rodrigues was custodial. Custody is when a reasonable person would believe that he was not allowed to leave. And custody doesn't turn on one thing, it results from a combination of factors. We don't address them seriatim and dismiss them. It's like a sufficiency inquiry. It's all the evidence
The
together.
groom factors, correct?
Yeah. I mean, they've been articulated a number of times, but that's what we call them, yes. So the case starts with Rodrigues being approached by multiple officers with tasers drawn, yelling, "Police, police." He's separated out with Mandy Perry, the co-defendant.
Counsel, can I interrupt for a moment? So we're really familiar with the facts. So we have read this case.
Yes.
And so when I look at the groom factors and I say, no, it was in public. And after the end of the conversation or inquiry, he left, right? So when you look at all of the factors, I get it, right? Approach, taser, and all this. But if we specifically look at those factors, how do you weigh the fact that he's on this in a public area, on a sidewalk, right? And sure, he was handcuffed momentarily, but he also went home.
So there's a number of responses to that. I think Earl is a great example of that. That's on a public street. The Commonwealth relies on Vellucci. I'd like to talk about that. But the inquiry of he's allowed to go at the end, that really is most relevant in cases like Fisher, where the defendant is told that he's free to leave and then he does leave. There's no evidence that Mr. Rodrigues was ever told that he was free to leave. And it wasn't momentarily, I mean, depends on how you define momentarily, but if you add up the times that Officer Camera talks about, it's at least 30 or 40 minutes that he's on the curb, in cuffs, there are emergency and police vehicles arriving, lights flashing, there's a prone, bleeding, dying person 50 feet away.
Right, but the reason for the cuffs was because the police were responding to a completely different issue at that point in time, and Mr. Rodrigues wasn't settling, right? So it's chaos.
So,
and they needed to take control of the situation, correct? I mean, they weren't even looking and inquiring at that point in time about the death of the victim.
well, so there's a couple of things about that. First, the two other participants were not cuffed. Second of all, it doesn't matter what's in the police officer's mind about why they're cuffing him for safety. I'm sure they were cuffing him for safety, but he wasn't told that. There's no evidence that he was told that. And then the tenor of the questioning, which is where we really, we start with the tasers, but then we get to the tenor of the questioning, right? Which is the first question to him is motion to suppress page 25. Why are you running up towards this gentleman and saying you're going to kick in his door? That's an accusation of a crime. Right? That's how we start, and then we immediately get to motion to suppress page 32. I called him on it. I don't think he was telling me the truth about his sneakers and about where the blood was from. So he's already asked him, why do you have blood on your sneakers? Where'd that come from? And motion to suppress page 33. I was asking him specific questions, and he said, no, that's not his blood. So the specific questions had to have resulted in that response. So that's the tenor of the question. So public place, the Commonwealth talks about Vellucci. That's a very different case, right? That's a traffic stop. The guy approaches the officers. This is not a traffic stop. This is the officers coming at him. He doesn't go to them. In Vellucci, the questions were general. What's happening? Here, they're pointed. They're not, quote unquote, vague and unformed suspicion. As I said, the very first question communicates that we think you've committed a crime, right? That you're committing an affray. You're threatening Mr. Schwartz. And asking about the blood is significant, right? Because nobody was injured in that argument down the street on Albion Street. But there is blood 50 feet away. So I think that also creates the coercive environment, yes.
The nature of the questions are investigatory, certainly.
Yes.
But that does not determine the question of custody.
it's a factor.
Right.
Yeah, yes. And so they were aggressive. I mean, you know, the cop tells him, "You're full of crap. Give me your sneakers."
Let's set aside for a moment the question of whether he was in custody or not, and look at prejudice, because the responses, his specific responses, are not. I know you said that this was a close case, the evidence was not overwhelming, but even in a close case, the specific responses that he gave, the statements that are at issue, related to Miranda, all denied involvement, right?
Yep.
How were they inculpatory? How did they tip the scale in the jury's mind on the question of guilt?
Yes, Your Honor. So I would just rely on the Commonwealth's view of it, which is you look at the prosecutor's closing, pages 82 and 83 of Volume 6. She relies on those false statements as consciousness of guilt, as evidence of intent, right? And she also, the fruits of that interaction, the sneakers, she relies on that as evidence of malice.
Well, the sneakers, it seems to me, are in a different category than the statements. I'm, for the moment, talking about the statements themselves.
Right. And so the top of page 83, she specifically argues them denying involvement as evidence of
I understand that the Commonwealth made reference and incorporated that evidence in their closing,
Right.
As they were entitled to do because it was evidence admitted at the trial.
They were.
I'm going more to the question of their significance. Consciousness of guilt certainly bears on the question of intent, but so does the severity of the beating. And it seems to me that a jury will surely infer malicious intent in a beating with the shod foot that results in injury so severe that the victim dies.
Right, and that's why the sneakers is important.
The sneakers are important. I will grant you that. So let's talk about the sneakers.
Yes.
The sneakers were kicked off voluntarily, right?
No, I wouldn't call that voluntarily. You're full of crap, give me your sneakers is not voluntarily. Now, the problem here is that camera gives multiple versions of what he said, but none of them contradict each other. And it's very clear that he's focused on the blood from very early in the interaction, and he accuses Rodrigues of lying and then demands the sneakers with no Miranda warnings. So it's
Say none of them contradict. They seem contradictory. I guess I'm wondering what the officer's definition of ask is. He testifies a number of times he asked for the sneakers, and then he quoted himself saying, you know, as you say, you're full of crap, give me your sneakers.
Right.
Is that not contradictory?
So I think it's, page 50 of the motion to suppress. Officer Camera, to my mind, defines what he means by ask. And so you have to go back and read it, but my quote here is, by asking, he means, in the context of the questioning, okay, quote, okay, now I think you're full of crap, give me your sneakers, and he says, okay, sure. That's what he means by ask.
Well, I say contradictory because if you're asking us to find that it was involuntary, that would be finding the judge made clear error on his finding that he did not demand them, he asked for them, correct?
So no, I don't think that's a clear error. If you look at the motion judge's ruling on this, what he actually says is, addendum page 52, if it's your blood, then give me your sneakers. So that's not asking, right? So I think it is a demand, and I think it is a fruit, and I think it should be suppressed, and I think it is prejudicial.
But it's a factual determination, counsel, isn't it? So in other words, when we review the judge's findings.
Well, so I'm not asking you to second guess that finding on addendum page 52. If it's your blood, then give me your sneakers. I am asking you to, so that is a finding that is applied clear error. But the ultimate constitutional question of consent and constitutional rulings, they are reviewed de novo, right? Because, and that makes sense because applications of law to fact, oh, I'm sorry. Wait, I think you're muted, Justice Walsh.
Judge Walsh, we can't hear you.
I am, thank you. If there's conflicting evidence and the judge finds that, because there is some evidence in the record that your client kicked off his shoes and like, don't believe me? Here, take them. There's also evidence in about I asked, right, for the sneakers. So there, it seems to be a little bit all over the map of what really happened, but the judge found that it was not a demand. And so I guess my question to you is that under the standard, that's a factual determination. You're asking us to say, judge was clearly erroneous in making that determination because this is what the law says, right?
I'm happy to make that argument, but I don't think you need to go that far because I think the factual finding is camera said, if it's your blood, then give me your sneakers. Then the judge makes a legal finding that that was not a demand, it was a consent search, right? And that's, I think you can review that de novo. So if I have time, I'd like to move to the closing argument.
You have a minute and 17 seconds.
So the point here is that this prosecutor was extremely experienced, and she timed her comments appealing for sympathy. You know, Dennis Cousino may have had his own crosses to bear. He certainly had a high blood alcohol at the time of his death. That doesn't mean his life was out worth or he deserved to die this way. It's asking the jury to pity Cousino and loathe Rodrigues, and then the explicit religious reference makes it worse. It wasn't justified. Defense counsel was arguing the facts as he was entitled to. He was arguing his theory that Cousino tripped and fell. That's what, you know, drunk people do, right? Is they trip and fall, right? Sometimes they're aggressive. Sometimes they make jerky movements, right? She wasn't justified in doing this. She could have objected. She could have asked for a limiting instruction. Instead, she contravened what the SJC said in Durgo. Don't fight fire with fire. Ask for help from the judge. That's not what she did. She wasn't justified in doing it. Referencing to the grand jury that, you know, the jury never heard that this was a justification for making this reference. That's not fair play because, you know what, there was a lot of evidence about Mr. Cousino that the defendant wanted in that never came in either. So we don't want to play that game. Right. We have to go on the evidence.
Thank you.
Thank you.
Morning.
Good morning. Thank you. May it please the court. Stephen Nadeau on behalf of the Commonwealth. Obviously, we're asking the court to affirm Mr. Rodricks' conviction today. I'll begin, as my brother did, just touching on the strength of the evidence very briefly. Obviously, our position is that it was an overwhelming case, perhaps not for first-degree murder. Obviously, the jury did not think so, but for second-degree murder and to malice in this case, certainly the evidence was very powerful. And speaking just, again, a witness by two women, this altercation unfolding on the street, corroborated in certain respects by a admittedly poor quality video. And as far as citations on the malice issue, I don't have them in front of me, but in the first brief that was filed, there was a 25B2 sufficiency argument raised. I don't know whether the court still has access to those, but
Mr. Nadeau, do you agree with the observation that I made, or the suggestion I made earlier, that the sneakers were important elements and the testing of the blood from the sneakers was an important element of the Commonwealth
I'm sorry,
case?
can you repeat that, Judge?
The sneakers, and particularly the blood, the match between the blood found on the sneakers and the victim's blood, that was an important element of the Commonwealth's case?
Yes, yes. But
So let's go there.
Sure.
On the motion to suppress. What do you have to say?
so those were provided by the defendant's own consent. Again, there was sort of a exchange where he characterizes it differently during the hearing, Officer Camara.
That consent affected by the question of custody and Miranda?
No, I believe those are separate analyses, although how coercive the demand is a factor, but it's not subject to the groom factors, if you will. In fact, even, you can be under arrest and consent to talk. You can be in jail and agree to talk to police. You can consent to various things, even in the most, circumstances where you're most deprived of liberty.
How long had he been sitting on a sidewalk handcuffed before he provided the sneakers?
That, I think, is not entirely clear. There was not a specific finding, but I do agree with whether it seems like there was the initial conversation with the defendant, I think is testified to about 15 minutes. Then he goes to speak with John Russo, the officer, and that is maybe another 10, 15 minutes, and then comes back. And that's, I think, that second interaction is where the conversation about...
You'd agree the inference is not less than 30 minutes he'd been handcuffed sitting on the curb before he gave up the sneakers?
I think that sounds like a reasonable, but again, not totally clear. I think there's some testimony that a lot of things were happening at once, so it's not totally clear that was necessarily one after the other. But 30 minutes ballpark, give or take, certainly. But as the judge found, the statements kind of going to were made before the question whether the sneakers began in that first 15-minute chunk. He'd already made these statements that are challenged primarily prior to the conversation turning to the sneakers, and then again the groom factors don't apply. And here there was not just here, take them, but I'll kick them off for you. So even the kind of coercive environment of being in handcuffs can be overborne by his active assistance in consenting in that case.
I think the other question I have about the sneakers is, you're saying it's a distinct inquiry from the Miranda, which I agree, but if we were to find that there were statements in violation of Miranda and then the sneakers came after that, would they not be fruit of potentially that illegal act if we did find it were a violation of Miranda? It came subsequent to statements, correct?
Yes. That's a good question. I hadn't thought of it in those terms. I don't think so. Well, because, the defendant did bring up the I don't have a quick answer to that, but my instinct is no.
The defendant's counsel in his argument described them as fruits.
Yes. But again, that was a sort of separate track from the initial conversation. The defendant himself brought up the fact that there was a fight. That was not where the questioning by the officers was leading. So again, I think there's a aspect of the defendant sort of interjecting this into the conversation. But while I agree that the sneakers are a key piece of evidence, even if those were fruits that should have been suppressed, obviously our position is they should not have been, but even if those should have been suppressed, the evidence is still overwhelming, although certainly helped, and that's because this was an eyewitness case where there was a subsequent photo ID. Again, two uninterested parties recognized the severity of the beating from within their homes late at night. This wasn't broad daylight, but still they were able to.
Well, how do you describe, Ms. Perry got a pretty clear view according to her testimony. I believe she testified the defendant was pounding on the victim, and she didn't see any kicks, though. Am I saying the evidence correct?
I think she described both, kicking and striking. I think if you look at that with Karen Waring's testimony about the kicks being sort of a wind-up full kick back, you can sort of easily envision that he's just sort of winding up and...
Okay, I didn't think that witness Perry described both, but your memory is she described both punches and kicks.
My recollection is that there's both kicking and pounding in Susan Hart's testimony.
Let's say if she didn't hypothetically describe kicking, she only said there was punching, would that be an issue for the strength of your case?
I don't think so, no. Again, clearly there was a beating. She was able to see the initial sucker punch, and then kind of however it happens, this defendant is beating, whether with his hand, whether with his foot. Two women can make that out as much. And then the fray, which...
Oh, no, but what you're doing is you're relying on a description by an eyewitness that is not entirely consistent with the manner in which the beating in fact occurred, as being sufficiently powerful to overcome any prejudice from the evidence provided by the sneakers. And that's a tough sell if she describes a beating that doesn't involve kicking. It goes both to identity and to the strength of her testimony to overcome the potential prejudice by the sneakers. That's a tough pitch.
Well, I mean, I don't know, we don't know that it may have involved both hands and fists. In fact, the fact that there was a sucker punch indicates that there were hands and feet involved. So that could have easily carried through the entire beating, although Ms. Waring only testified to seeing kicking, forceful kicking. But regardless, what there's no dispute discrepancy between those two women is that the defendant was beating Mr. Cousineau on the ground. So that is established clearly and well corroborated by the video evidence. So, you know, that settles that. If there are no more questions.
You say well corroborated by the video evidence. I thought the video was rather inconclusive as to identity.
On its own as to identity, but as to sort of the movement of the parties that you can see, that there's, you know, you see what the evidence, I think, establishes is the defendant coming down the street first, Mr. Cousineau following, co-defendant Mendy Perry following third. Then you see Cousineau and the defendant sort of meeting back at the corner. You can sort of tell that Mr. Cousineau falls, and then the defendant is still there for several seconds, certainly long enough to carry out this beating, long enough for Mrs. Hart to come out while the beating is in progress and have a sort of interaction back and forth, calling out, hey, he's unconscious, you're cowards, that kind of thing. And it's at that point that the co-defendant says, hey, we got to get out of here, and they sort of run back up the street. So that, again, is all happening.
But that witness didn't make an identification, correct?
Sorry?
Ms. Perry didn't make a photographic identification, correct?
I think Karen Waring made the identification. She did the photo array, and Susan Hart did not make it. But they both testified that the person who was doing the beating was the individual that the police brought down to the corner. And then I think it's Karen Waring who makes the affirmative identification. That's the defendant. And certainly those testimonies connect with each other and are sort of, I think, mutually reinforce the strength of their eyewitness testimony. If there are no other questions on the suppression issue, I will go to the closing.
I do have another question on the suppression issue. We understand that not every Terry stop is custodial, not every detention is custodial. But do you cite any cases where someone was in handcuffs for 30 minutes on an investigatory stop?
No, and I'll even sort of within the past few days and this morning, I made a last-ditch effort to try to find something on that length of time. I know my brother, in sort of somewhat different circumstances, talks about, you know, the length of time needed to detain for just a traffic stop, that kind of thing. So I agree that the time is relevant, but I couldn't find anything on this issue.
And you agree he was suspected of something from the very beginning when the officers approached? He threw a knife?
I don't know that I agree with that.
Did he admit to throwing a knife right away?
Sorry?
Did he admit to throwing a knife?
I believe he did, because I know, and then John Russo acknowledged ownership.
Before the statements were made, correct?
Yes. But that's still before sort of anything has happened. At that point, it's just an altercation, and it seems to be an argument. The officer's trying to get to the bottom, like figure out what's going on, and, you know.
Well, he didn't handcuff the other individuals, correct?
And it appeared that the other knife came from Mr. Schwartz. He was not handcuffed. That was not the issue. The issue was that Mr. Rodricks would not settle down. It was a chaotic scene, and they were just trying to figure out what was going on. Of course, although Mendy Perry was briefly handcuffed, she was allowed to leave and go get a spare pair of shoes for the defendant so that they could then walk away as they did. So, you know, I think the overall tenor of the interaction is that this is not a crime scene that we are locking down. This is permeable. You know, no one here is under arrest. And that's borne out by, again, the judge's findings, the testimony, and I do note that, again, the defendant may not have realized at the beginning of the interaction that he would have been free to leave by the end of it, but Commonwealth versus Earl, I think itself says that the interaction has to be evaluated from beginning to end, as far as considering the groom factors, and of course, at the end, he was free to leave.
Why don't you address the closing?
Yes, so the comments about, you know, did not deserve to die this way, as we acknowledge in the brief, better choice of words. Prosecutor should not have phrased them that way because it sort of tends to implicate an improper appeal to sympathy, but I think clearly in context, that's not what the prosecutor was doing. It was a response, I think a fair argument under the circumstances, marshaling a defense to use the evidence, but an attempt to say, you know, Mr. Cousineau was drunk, he sort of brought this on himself, you know, drunk people can be aggressive, he appeared out of nowhere, that kind of thing, and so I think within that context, the prosecutor was trying to, and the jury would have understood that she was trying to sort of say, that's not what this should be based on. Your feelings about him being drunk, and I think at the very beginning of her closing, she says there's no evidence of that, and then so the focus is on the evidence. So rather than saying, you know, this poor thing, don't you feel bad for him, there's no evidence to support what the defense is saying, so don't be distracted by although we acknowledge he was drunk and he may have had his problems, but that's not what the case is about. And so for that reason, where there was no objection, it would not create a substantial risk, and was also not the, you know, overarching theme.
Let me back up for a moment, because I heard you say two things. First, you said, oh, she shouldn't have said it, but she was justified in saying it. And to me, when I read it, whether it's in context or not, she shouldn't have said it. Do you agree?
I agree, and particularly the use of words, but the substance of the argument, I think, of what it's clear in context she was trying to say was not appeal to sympathy, but the wording was improper because it invites that possibility, but would not create a
So what you're
substantial risk.
suggesting, I'm just trying to put what you're saying into a legal framework. What you're saying is that though the argument itself was improper, the force of its impropriety was mitigated by the context in which it arose.
Yes.
We'll
So many
think about
words.
that.
Again, the question being whether there's a substantial risk of a miscarriage of justice. I don't know if the court wants me to touch on the other.
We can take that from your brief, unless there are further questions. No, we will move to the third case on our list. Just as a reminder, we will take a brief recess following the argument in case number 2022 P1225, Halawi Investment Trust versus ALLRED, Bacon, HAFHILL, and Young PC, and others.
Good morning, Chief Justice Green, Justice Walsh, and Justice Smith. My name is Neil Goldman, and together with Adam Rowe, sitting to my left, I represent Halawi Investment Trust, referred to in the briefs as HIT, the plaintiff below and the appellant in this proceeding. This is a legal malpractice case resulting from the failure of the defendant attorneys to timely initiate arbitration proceedings against Boston Merchants Financial Limited on behalf of HIT following the wrongful freeze by BMFN of the funds it held in accounts that belonged to HIT, totaling approximately $1.2 million. As stated by the arbitrator in his decision dismissing the arbitration, BMF.
So can I interject here?
Yes.
So we have 15 minutes, and this is, to me, a fascinating case. And it's solely focused on collectability, correct?
Correct. At this point, at this stage.
Right. That's the issue for this court to determine. So my question first is, and if I mispronounce his name, please tell me, and at times it was Pavel and Paul Belagor, the owner, founder, and manager of BMFN. Would you agree with me that the deposition testimony that he provided specifically about collectability was hearsay? That's my first question.
Let me answer that first question, and I'll wait for you to do the other. The answer is no. The testimony was in the nature of an opinion by a lay witness under Rule 701, Massachusetts
Okay.
Guide 701. And
So let me interject there. Let's hypothetically say that I own a 2002 Ford Thunderbird, and the issue of the value of that car comes up. I'm the owner. Right? I bought it. I think I could testify my opinion about the value of the car. That's opinion testimony, right? Many bases you cite about value of companies or property, etc., is just that, opinion. To me, whether, in this case, BMFN could pay out something is an opinion testimony. And I want to hear your argument of why it is. It's fact testimony. It's almost like what's the bank account? How much liabilities? How much debt? How much profit? Can they pay something? That's a fact, not I think so and you think not, and here's why I'm right and here's why. It's to me, a fact testimony that requires personal knowledge. So tell me why you're viewing this in the lens of opinion testimony.
Businesses and their financial condition are fluid and based on a number of factors and events that occur over time. And it's not static. So it is opinion testimony based on fact as to whether or not at a given period in time the company has the ability to make the payment.
It's opinion testimony based upon fact. Okay, I got you that far. So next question I have for you is, let's separate the two issues of Paul Belagor as owner, founder, manager of BMFM for a moment, because that's a separate issue, versus, hello, unnamed Russian accountant, do I have money to pay the bill? How is that conversation not hearsay? Tell me that statement.
It's more than the conversation. The conversation and the information and the guidance received from the accountants is information that Mr. Belagor, in his capacities as owner, founder, and manager, considers in making the determination about whether or not they're funds sufficient to make this payment.
I'd like to
See,
come
I
at
don't
this.
want to morph all of it together. I want to separate owner, manager, founder, what he, in this instance, knows about the running of the business in order to give testimony about an ability to collect, versus conversation with a third party who I'm assuming has personal knowledge, but since I don't know his or her name or what they reviewed or anything, I'm looking for your legal argument how that piece of it is not hearsay. And if it is hearsay, where the exception to the hearsay rule comes in.
The statements by the accountant are hearsay. The opinion by Mr. Belagor informed in part by the statements of the accountant, are not hearsay. That's his opinion testimony that's admissible under 701.
Let me try to come at this, if I may, from a somewhat different perspective. You're relying largely on the federal rules of evidence, 701, which is consistent with Massachusetts treatment, which recognizes that an owner generally will be considered competent to provide an opinion testimony about the value of their possession. In your view, is that a categorical rule, or is there room for the judge to develop an assessment of the basis of knowledge?
It's not a categorical rule.
I didn't think so. And so if we accept the premise that the judge, in assessing whether to treat the opinion testimony as competent, conducts an assessment of the basis of knowledge for that opinion, what is our standard of review of the determination made by the ruling judge?
The standard of review on summary judgment is...
No, I'm talking about the standard. The judge has made a determination. I understand that we consider the evidence in the light most favorable to the non-moving party. But the question of whether evidence is admissible is a question of law, correct?
Correct.
Okay. And we can assess the judge's ruling that the evidence, the judge, in effect, ruled that this evidence, this opinion testimony, was incompetent and inadmissible, and she would not treat it as proper for consideration. Therefore, it's not part of the evidence that we consider in the light most favorable. She's excluded it, in effect. And in doing so, embedded in that ruling, I believe, is an assessment that the basis of knowledge is inadequate to support its admissibility. Right?
Yes.
And we review that ruling by the motion judge under what standard of review?
Evidentiary rulings are typically made on an abuse of discretion.
Okay.
So
what we have is a motion judge who reads a deposition transcript, as we have, that says that you said largely, but my reading of the deposition transcript is that the sole basis Mr. Bellagore offered to support his understanding of the value of the business and its capacity to satisfy a hypothetical $1.2 million judgment at the relevant time was conversations with accountants on the Russian side. And the judge, hearing that, said, I think that's sketchy and inadequate to provide an adequate basis for a competent opinion. Right?
Yes.
Okay, and you're asking us to say that that was abuse of discretion.
Yes, I am.
Okay, tell me why.
It was done solely on the written record, on the deposition testimony. There are inferences that should be drawn by virtue of the source of the testimony, Mr. Bellagore as the owner, founder, and manager, and that he managed the business, that there are other factors that go into it other than what he was told orally by the accountants.
Such as?
Such as the prospects of future earnings, the collectability.
Isn't all of that available on I understand that this is on summary judgment, but what would have been different had the same evidentiary presentation been made at trial?
I believe it would have been more fulsome than it is. Admittedly,
every incentive for development of the basis for the admissibility of this evidence was present at the deposition, right?
Yes.
So when you say it would have been more fulsome, I guess I'm struggling a little bit to understand why, if there was more to be done, it wasn't done. This is a foundational element of the case that you needed to make. and it was known to be that at the time of the deposition. You're going to throw everything you can to qualify this witness to provide that testimony. What more, I mean, it's nice for you to say that there would have been more, but there was no proffer, there was no, I'm not sure. I read the testimony. This guy didn't have a lot. You could have asked him 18 different ways, and he's going to give you the same answer.
And candidly, Your Honor, I was surprised at the time of the deposition. I tried to get the information, and, the witness felt that his testimony, that he had sufficient funds to pay it, was sufficient.
Well, he's not a lawyer.
I understand.
And what he's offering to support his basis of knowledge, as the football coach would say, it is what it is, but it's not very much. So now we're looking at a judge who looks at what you have on the record and draws a conclusion that the support for his opinion, the basis of knowledge, is inadequate to make his testimony to that effect competent for admissibility. And that's a classic discretionary call, and you're asking us to set it aside.
Yes, I am. One factor here as well, Your Honor, all this has been framed as, a question of admissibility of that testimony. There is the fact that's established in the pleadings and in the record that BMFN took the $1.2 million, and in the words of the arbitrator, if I may, they liquidated the account and kept the money. So that is a fact that's established on the summary judgment.
Where is that in the record?
It is in the complaint. And
I'm talking about in the record.
the complaint is part of the record.
Well, no, but it's not evidence. Complaint isn't evidence. I'm just looking for the evidentiary support.
It's Appendix 1, page 148, which is the complaint.
So, counsel, in some ways, I feel like you're making your job harder than it has to be, right? In the sense that you don't need to establish that BFMN could pay the full 1.2, right?
Correct.
I mean, the case law is clear that however you define something. So if we set aside for a moment our disagreements about the admissibility of the unnamed accountant, it seems to me that your position is that as the owner, founder, and manager of the corporation, that given the standard of the light most favorable to your client, that the reasonable inference is, and you could survive summary judgment by, in essence, his position as owner, founder, and manager, that of course he has personal knowledge that he can pay something. Is that enough?
Yes. Under the cases, it's enough.
And let me also say that I believe it's the Foley Hogg case that says it's not enough even just to prove assets. Right. Because you got to show liabilities, right? You got to show the debt. So I scoured that record.
The testimony of Mr. Belajour was that the opinion that he stated reflected both assets and liabilities, not just assets. And I agree with Your Honor that to survive summary judgment, we don't need to establish that the whole thing could have been paid, just that something could have been paid. And that's clear from the record.
So let's not take this case, but the hypothetical case of almost a puppet owner, and I'm not suggesting Belagor is, but owner, founder, manager in title. That's enough to survive summary judgment because he or she is presumed to have personal knowledge of the assets and liabilities?
Yes, from whatever source, including conversations with the accountants.
All right. I see that we're out of time. Unless there are further questions, I think we'll move on to hear argument from the appellees.
Thank you, Your Honors.
Good morning, Your Honors. My name is Chris Storm. I represent the Bacon appellees, and Attorney George Rackus is going to argue for 5 minutes. I'm going to take 10 minutes on behalf of the Chalai appellees. Your Honors, as you have all pointed out, that this is an appeal that turns on the principle recognized in the Jernigan case that collectability is an essential element in a legal malpractice case. And I believe...
Well, but it's even narrower than that. It turns on this, this core evidentiary question, right?
It does. This is a case that's resolved essentially by 4 pages in the record appendix I would submit to Your Honors. Volume 4, pages 52 through 56. Those are the relevant portions of the Mr. Belagor testimony in which he's asked the questions that establish what is the basis of his information supporting his collectability testimony. And as a matter of, just to clearly address the question that Justice Walsh had asked, is Mr. Belagor's testimony hearsay? It is hearsay. And the reason it's hearsay and shouldn't be relied upon as competent evidence is because he testified in his deposition that the sole basis for his testimony that BMFN had adequate funds on deposit was the Russian
His testimony isn't hearsay. His testimony, his opinion, his testimony is an opinion. His opinion may rest on hearsay.
Yes, I'll be more precise. The statement of the Russian accountant is...
But it's not the statement of the Russian accountant that's being offered for the truth of the matter asserted. It's Belagor's testimony, and his testimony is he would have been a witness at trial. So we're really, this is classic opinion testimony based on extrinsic evidence.
Your Honor, we would argue that his opinion testimony isn't going to clear the Rule 701 bar because he hasn't demonstrated through his deposition testimony that he has sufficient familiarity with all of...
I understand, but that's a different point. What do you have to say about the argument that we heard toward the end of our exchange with the appellant's counsel that there was an independent source of evidence establishing the capacity to pay in the form of the arbitrator's finding cited in the complaint that they liquidated the account and distributed $1.2 million?
Your Honor, I don't think that passes muster. The point, as I understand the case law, what is required by the case law is to conduct an analysis of assets minus liabilities and make a determination that there would have been money to pay a judgment. The arbitrator found that they converted $1.2 million, but there's no testimony in the record of this case as to how the financial position of BMFN evolved subsequent to that conversion. There was a lengthy period of time, I believe on the order of at least years subsequent to the arbitrator's finding. We don't know what other secured obligations developed. I believe one member of this panel had asked the question, is it required that under the case law that kind of additional information be provided in order to establish collectability? The answer there is yes, and that would be under the von Henneberg case, which is cited in my brief, and most importantly, the Pauley versus Moylan case, 423 Mass 141. standing for the proposition that you need information about the state of the finances, the existence of secured obligations and other debts owed. So my argument, Your Honor, is that it's not enough to say that at one point in time there was $1.2 million converted into this account, because we simply don't know. There's nothing in the record that tells us what happened subsequent to that up until the time when...
Or what other prior claims may have attached to that distribution.
Exactly right, Your Honor. And in fact, Mr. Belagore was asked point blank in his deposition, what were the assets and what were the liabilities, essentially? How do you do the math in order to come out to
He disclaimed any awareness of
Exactly
those.
right, Your Honor.
Yeah.
Yes.
But counsel, even if he disclaimed an awareness, I mean, would you agree with me that it's not a very high bar for Paul Belagore or for HIT to overcome?
Well, Your Honor, I don't know where I would set the bar, but I would submit to you, Your Honor, that if there were ever a case in which an owner should not be deemed by virtue of his status as owner or manager to have the capacity to meet that bar, it's this particular case.
Let me ask that question in a different way. Suppose the judge had made the determination that she thought that the claim survived summary judgment because Balagore's testimony was based on a sufficient foundation. Would that have been an error? Would you be asking us to set that aside for abuse of discretion?
I believe I would, Your Honor. I mean, the judge is entitled to substantial discretion, of course. However, Mr. Belagore was asked directly, were you provided financial records?
As the owner-manager, I mean, he was with this company for quite a substantial period of time before it ultimately was dissolved, and it would not be too great a stretch for a judge to accept the premise that someone in his position would have had an adequate basis to know, at least in broad strokes, that the company had sufficient assets and net of liabilities to satisfy a judgment of that, depending on the scale of the operation, relatively modest sum.
But, Your Honor, we're still back to a hearsay problem there because no financial records were kept internally at BMFM.
That goes to the weight, not the evidence, because it's opinion testimony. Weight, not sufficiency or admissibility.
I understand Your Honor's argument, but I would submit that as the owner, he still needs to testify based on some degree of familiarity with records that show what are the actual dollars.
He had ongoing involvement in operations of the company. And as to the specific details of the books and records on any given day, of course he's going to rely on members of his team to maintain those records. But if he, in an order of magnitude, let me suggest that I've lost track because Bill Gates has now left Microsoft. But if he were asked if his company could satisfy a $1.2 million judgment and testified yes, we're not going to expect a lot from him to substantiate his knowledge of that foundational fact, right?
Understood, Your Honor, although this isn't Microsoft, and I would point you, Your Honor, toward a case that's not cited in my brief, but is cited by the Viper Ventures case, which features heavily in my brief. That's the Quinn Brothers versus Wecker case. It's 414 Mass 815. And in that case, Your Honor, an owner of a company was a trustee was permitted to testify as to the interest costs that a trust paid, but not as to certain expenses invoiced to the trust because it was hearsay. And so I would still submit to Your Honor that somebody who is in a managerial or ownership or leadership type role certainly has experience that entitles them to testify broadly about the financial position of the company. But baked into that, and that opinion I think is necessarily contingent upon certain records and certain other financial obligations that need to be brought in under the business records rule or their hearsay unless there's some kind of exception to the rule established. And so I don't think it's enough, Your Honor, for Mr. Belagore to come in and say, I'm owner, I'm manager, and we had sufficient funds to cover it. Certainly, on the record as established and as the judge had found appropriately, Mr. Belagor didn't have adequate familiarity, and so summary judgment should be affirmed.
So let me ask you two questions. One, very quickly, is, counsel, you're in agreement that Paul Belagor's testimony is opinion testimony?
I don't even agree, Your Honor, because I don't think he has sufficient factual familiarity to meet that first bar. He has no personal knowledge, as he testified.
No, but his testimony about collectability, whether it was sufficient or not, but the testimony about the ability to pay something, you're agreeing is opinion testimony?
I would say, Your Honor, yes, we're not contending that he is not able to proffer his opinion. We're arguing that his opinion isn't admissible.
So secondly, don't we need to end this stage of summary judgment, not only provide every reasonable inference in favor of the non-moving party, but also read the deposition as a whole? In other words, Paul Belagor was asked a number of questions about the operations of this corporation in general. And he was able to answer them. So it was as if they just put a stuffed shirt deposition, right? I mean, this is a person who owned it, who managed it.
But, Your Honor, I'm
Yeah.
sorry. I didn't mean to interrupt you, Your Honor. I'm so sorry, I keep stepping on you. I would just answer your question and end by saying, again, on page 56 of the Record Appendix, Volume 4, Mr. Belagor was asked directly, what do you base your testimony on that you could satisfy the judgment? He doesn't say my opinion, he doesn't say my status as owner, he says the statements of the Russian accountant to me by telephone. And I think that controls here.
All right. We'll hear from Mr. Rackus.
Good morning, Your Honors. I know there's been a lot of back and forth about whether opinion, fact, the fact that Belagor was an owner of the company. But I think to give weight to the opinion of an owner of a company as to value, he has to have particularized knowledge. And I just want to read from a case that's cited in the Guide to Evidence Rule 701 under the section on value. And they cite a SJC case, and it reads, ordinarily an owner of property is actually familiar with its characteristics, has some acquaintance with its uses, actual and potential, and has had experience in dealing with it. It is this familiarity, knowledge, and experience, not the holding of title, which qualify him to testify as to value. And Mr. Belagor demonstrated nothing about knowing anything about the company other than what this accountant told him. He couldn't identify any records, couldn't say I reviewed financial records at points A, B, and C in time. He's just going solely on what the accountant said. And we don't even know who this accountant is.
Let me ask you this, Counsel. Introduced into evidence in the summary judgment were broker agreements, correct?
Yes.
So 2010, 2012. And
yes.
For a layperson, these are some sophisticated parties. Would you agree making some transactions that the average person doesn't make? The business they were involved in was
Yes, there
sophisticated.
was complicated agreements and complicated transactions.
Agreed. And the broker agreement was lengthy. There were obligations on both sides, correct?
Yes.
And that was signed by one person from BMVI, and that was the deponent. How do you pronounce his name?
Belagor?
Yeah, he signed them, correct? So he's signing the broker agreement. What inference you draw from that? He's representing all the obligations that his company will provide. He's essentially signing off on the entire agreement between the two parties. Does that not entitle him to some sort of weight in what the party's worth is?
I don't think.
Or what obligations they could meet?
I don't think an agreement with a customer is evidence of the financial wherewithal of a party. Just because you sign an agreement, it is meaningless, really. You have to have something in the bank. You have to have assets. your assets, not the assets of your customers.
And we can't infer from that broker agreement that he would have access to that information?
No, you can't, well, he didn't say, he testified specifically, what is the basis of your opinion or claim that BMF could satisfy a $1.2 million judgment? It is what my accountant told me. And again, we don't even know who this accountant is. We don't even know if this accountant did the actual record keeping for BMF. It could have been a partner in an accounting firm, and all the information the partner was given was by some young accountant associate who said, this is what I found, this is all the information. Then the accountant goes, picks up the phone and tells Bellador, conveys the information to Bellador. So, I mean, it could be hearsay layered upon hearsay. That it wasn't my obligation to bring out that information on the summary judgment. The plaintiff in this case had the burden to establish collectability, not the defendants. And they did none of that. The record is devoid of any of that. So it's really, it is what it is. It's a very scrawny record. And the testimony is hearsay, and it's also opinion testimony that doesn't meet the threshold of someone who testifies about the value of his or her business.
Counsel, in your statement, you quoted a case cited from the Federal Rules of Evidence. What case was that? The not holding of the title?
It's actually, it's in the commentary under value, and what I quoted was the case Mency versus Orton Crane, 285 Mass 499. And again, that is a quote directly from the commentary to the Guide to Evidence.
So different from opinion of value. This is, or what does this contract mean? It's how much money in the bank versus how much do I owe everybody so that I could pay something. And my question again is, don't you think at a motion for summary judgment stage, the fact that he was the manager, owner, and founder, that he is, you might not agree with it, but that he's qualified to testify, yeah, at the end of the day, we have enough money to pay out something.
No, it doesn't qualify. This was a guy in Russia that got information from his accountant. He didn't look at any financial records. He couldn't identify any financial records he looked at. He does not qualify as being competent to testify as to that fact. It's solely based on what an accountant said, and that accountant, what he told Mr. Belagor could be based on hearsay itself. There could be multiple layers of hearsay. We don't know, but it wasn't my job to figure that out. As the defendant, it's the plaintiff's job. They have the burden. They fail to meet their burden.
Okay. I see that your time has come to an end as well. That will conclude the argument in this case, and the case is submitted. We will take a recess and resume our session at 11:40.
All rise. We'll stand on recess.
We continue our session with case number 2022 P893, Commonwealth versus Robert Hersey.
Good morning, Your Honors. Tara Ganguly for Robert Hersey. Two issues for the court in this case. I'll start with the motion to sever or motion for relief from prejudicial joinder. The two types of crimes in this case, the defendant argues, were not so similar types of crimes as to warrant joinder in this case. The sexual assault contact crimes is a substantially different kind of crime from taking photos of unsuspecting victims. This is not a case where it's the same crime against different groups of victims. Here it is two separate types of crimes against two separate groups of victims.
Let me ask you,
Sure.
we're very differential to the trial courts on these motions. Were you able to find any reported case in Massachusetts in which an appeals court has determined a trial court has made an error in joining charges for trial?
I was not, Your Honor, and I did shepherdize the cases that my prior counsel put into his brief. There's always a first time for everything, Your Honor.
That's exciting.
It is.
This is an opportunity to do something that we've never done before, but you know that that's not the way we typically operate.
I understand.
So we would need a rather compelling reason to do so. The principles that typically come into play on a question of joinder or severance of charges is whether evidence of one crime would be admissible in the trial of the other.
Yes, and I know the Commonwealth focuses on this factor substantially in their argument, but at the end of the day, I do think that the admission of one set of acts to prove the other set of acts, if they had been in separate trials, still points to propensity, even if you can arguably dress it up as something else that might be admissible.
Well, it's not arguably dress it up. I mean, I understand that the distinction between propensity and pattern is decidedly subtle.
Yes.
But it's not just pattern, it's also intent, right?
Correct, but the intent of the two types of crimes is different, in my opinion. One is substantially more, I would argue one is substantially more harmful than the other, and one does not.
They do bear some relationship to each other, right?
Yes, yes.
And that relationship rests on an interest of a sexual nature.
Correct.
So you would you argue that it would have been error to admit the photographs in the sexual assault trial?
I believe there would have been substantial argument and motions in limine and discussion between the parties.
I understand that, but in order, in order to win the argument that you're advancing to us here, it's not enough to say that it would have been a substantial question. You would have to say that it would have been error and abuse of discretion.
I would, if in that situation a judge had admitted the photographs to prove the contact offenses and there had been a conviction, if I was given that case on appeal, I would argue that that would be error to have admitted because the photographs would have been so prejudicial to the defendant in the other set of crimes. So I would argue that that would have been an error.
It seems like, we'll hear from the Commonwealth, but one of the better arguments for why that evidence would be admitted and why joinder wasn't in error is that this is a person who uses position as a gym owner, a free gym, kind of his position of trust as well, and he influenced minors with that position to have a free gym, to coach people up, and that's how he got people in his car. And again, that's how they framed the case. I'm not
Correct.
I'm crediting that, but that's also how they he got people to go into a closet area or storage area and take photographs in the nude. So what do you say to that as not being related under that theory? It's a similar case, and it's cited by probably both parties. I don't remember the name. It was about the karate coach who groomed people in a certain way, and that was the court found to be the same pattern of conduct. And this is a little bit a step away from that because there's different actus rea, or there are different crimes, but it's the same sort of a pattern or approach, perhaps.
I think another way to distinguish is that these various acts happened over the course of months at different times. Yes, the defendant, all of these victims went to the defendant's gym, but you know, they weren't all from the same school. They were kids from the neighborhood, essentially. Perhaps a stronger case for my argument would be if some of the victims were located outside of the gym capacity. But I still think that the photographs essentially gave the jury enough oomph to convict on the contact charges, considering that the cross-examination of the victims on the sexual assault charges went to consent, was relatively, long cross-examinations in terms of credibility. And
so let me ask you a question, counsel. If we had a witness who was victimized both as far as contact and as far as being the subject of nude photographs in this grouping, would your position be the same?
I think that would be a harder argument for me, but that's not the case that we have. That's not the facts that we have. If there had been one, potentially two overlapping victims between the two types of charges, I think that would be a much stronger case for the motion judge in this case, in the court's decision, does not fully address the arguments that that trial counsel made regarding how my client's prior statements in the police cruiser affected his later statements after he was Mirandized. But when you review the interview video, he says, well, I might as well tell my side of the story, or I want to tell you my side. In the car, the statements that were suppressed were relating to his admission that he did take one of the victims to the massage parlor late at night. Now, he certainly didn't admit that there was any sexual contact when he made that statement in the police cruiser. He goes into that later, but I would argue that's not a good look to begin with.
But so this part of your argument goes to the cat out of the bag
Yes.
prong under Smyth or Prater. And how do you distinguish your case from Watkins? For instance, in Watkins, the initial statement, which was deemed in violation of Miranda, the defendant said he was with the co-defendant, but he denied, any inculpatory information. Then his later statement, yes, I was with him, and he made incriminating statements. And the court found that the cat was still in the bag by the time he made the later statements. This case seems similar, the fact pattern to me. Can you distinguish?
It's similar. I'm going to make a narrow distinction that the statement that he took, I think it was BT, to the massage parlor that night, that's not criminal conduct, so it's not inculpatory in the sense of admitting to a crime, but it's certainly evidence along the path to what that crime later turned out to be.
How so?
The defendant says at one point, you know, people have told me, you know, don't put yourself in that position, don't put yourself in a position where you can possibly get in trouble. And he did put himself in that position where he certainly got in trouble. You know, coaches, generally, it's well understood that they should not be driving around students and team members late at night, certainly to the type of establishment that he discussed with the officers. So I think that in and of itself is not inculpatory to the sense of...
It may be inculpatory to some extent, but it's not really cat out of the bag because it's not the same cat.
It's a kitten. I understand.
A puppy.
I understand,
Turtle.
Your Honor. But I think...
So when you say in your argument, Watkins does not apply, why doesn't it? What's different?
I'm unfortunately not remembering the exact statement in Watkins, the first statement in Watkins, but the first statement here, like I tried to just explain, is I would argue that it is inculpatory. The statement, I took this young person to the massage parlor that turns out to be where they do things that are illegal, is inculpatory. He probably could have been charged with a different, maybe like a reckless endangerment charge, or he probably could have been charged on that statement alone. That the Commonwealth didn't use that, but I think that is inculpatory. So I would just distinguish Watkins in the sense that it wasn't a perfectly vanilla statement. There was something inculpatory about it. And that would bring it under Commonwealth versus Smyth instead of Watkins. And as the court says in Smyth, the focus of this analysis is on the external constraints, continuing or new, which may have overborne the defendant's will. So I'm not going to get into whether he got the phone call, didn't get the phone call, but he didn't make a phone call. He's sitting there in a holding cell, in a jail cell, for 4 hours after his arrest, a little over 4 hours after his arrest. There was no break. Yes, it was 4 hours. It wasn't 4 minutes or 40 minutes, but he didn't talk to anyone else. He didn't see anyone else. He didn't make a phone call. In Commonwealth,
Conceding on appeal that there was no violation of his right to make a phone call. That was raised in the trial court, but that was not raised on appeal, correct?
correct, and the trial court found that that right was not violated, so I would concede that.
Intervening event, though, since if we were to find that, as the trial judge did, the motion judge, that the statements in the cruisers were unlawful in violation of Miranda, about 4 or 5 hours passed between the cruiser to the defendant getting his Miranda, is that correct?
Correct, about 4 hours.
And there was also, he also during that time had the opportunity to make a call, but he did not make a call.
Yes, I don't think that the legal argument is there for the violation of the right to make the call, but at the end of the day, he couldn't make the call because he didn't know the number that he wanted to call. And this is a very common, maybe the statute needs to be amended, I don't know. This is a very common situation in this day and age, that people don't know phone numbers. So he didn't, for whatever reason, whether it was legal or not, he didn't get to make the call. So he's just sitting there all this time, probably thinking to himself, this is bad, what am I going to do? Should I talk to them? Should I not talk to them? I already talked to them a little bit. Maybe I should, as defendants do, try to save themselves, but for that reason, I don't think that the waiver was voluntary.
I didn't want to take up your time with this, but the parties are asking us to determine if the statement were voluntary, and we review videos de novo, and I didn't see a submission by the parties, and I'll ask the Commonwealth as well as to the video exhibit. Was that submitted?
I'm sorry, that was the
The
video submitted?
interrogation that was recorded.
Yes, the Commonwealth submitted 2 exhibits, 2 CDs. One was the initial, I think about hour and 45 minutes of the entire videotaped interview.
Okay.
And the other, that was from the motion to suppress hearing. The other was the trial exhibit, and that was a redacted version.
Very good.
It is in the record.
Thank you.
Thank you. With Commonwealth?
Thank you.
Good morning, may it please the court. Assistant District Attorney John Wendell for the Commonwealth. Regarding the joinder issue, I'll begin there as well. The basic rule is single scheme or plan, and the Commonwealth would suggest that this case is the epitome of single schemes or plans. Every single one of these victims is in some way connected to this defendant only because he is their boxing coach, and every single one of these offenses is in some way connected to that role. The 2 who are photographed, they're photographed doing bogus weigh-ins. The 2 who are assaulted in the vehicle, they're receiving a ride from him because he's their coach. With JM, the younger of the 2, he's getting a ride to and from his boxing lessons. BT, the older of the 2, the one who ultimately reports and sets this whole thing off, he's receiving a ride because he specifically requested advice from his coach in his role as coach. So this is all very much a single scheme wherein he's taking advantage of his role as their boxing coach. I would suggest that there's actually substantial evidence that he set up the free boxing program specifically to give himself the opportunity to prey upon younger
So what
men.
if, for instance, while the children were out boxing, he went into the locker room, went through their pockets and stole their money, allegedly, and he was charged with larceny? Would it be fair to join those cases?
Well, in that case, then we have a problem of, we get into the realm of the cross-admissibility. And the reason I brought up this role of the boxing coach is I wanted to bring the court's attention to a case that I hadn't cited in the Commonwealth's brief, and that's Commonwealth versus Hanlon, 44 Mass Appeals Court 810 from 1998. That's an instance of a priest who is serially victimizing boys. And some of the offenses for which evidence was presented to the court, I believe they were out of state, out of jurisdiction, either that or they were beyond statute of limitations. I don't recall which it was. Regardless, they were admissible because they were evidence of pattern of conduct, modus operandi, et cetera. So here we have the cross-admissibility. The evidence of the photographs goes to the defendant's intent and also to the defendant's credibility. As to the defendant's intent, yes, he ultimately claimed consent as to BT, but as to the other 2, JM and ND, he claimed that they were lying. But then with JM, there's also, and BT both, there's this suggestion that he's pressing upon their stomach as part of some boxing drill, and then his hand goes lower, and that's when the assault happens. There's an argument there to be made. He ultimately seems not to have made it, but there's an argument there to be made that that was mistaken contact, that he had not intended to go that low. With regard to ND, there's the specific requirement that the Commonwealth prove intent to rape, the specific intent to rape. So the defendant's intent is very relevant here. And the photographs would suggest that he has the intent based upon his sexual interest. And in that regard, it's also relevant to the defendant's own credibility should the defendant take the stand, because he claimed during the interview with the police and also in his text exchange with BT that he was not sexually interested in males. The photographs would tend to rebut that. So if the defendant takes the stand, or for that matter, the portion of the defendant's statement that was presented to the jury has to weigh the defendant's own credibility. And these statements would tend to, these photographs would tend to be useful as impeachment evidence in that regard. So the photographs are admissible to prove the defendant's intent, his lack of mistake, and also to call his own credibility into question. And yes, Justice Smith, the Commonwealth did, as counsel said, submit the two versions of the video, one with the statement, "I'm not gay," and the other without it. Again, the defense was not made at trial that he was not interested in males, and these were complete lies, but his credibility was relevant because his statement was before the court. And I will just also mention briefly, the defendant has the burden of establishing prejudice in matters of improper joinder, and the defendant's argument in his brief is essentially, I was prejudiced because joinder was prejudicial. And the jury, I'll note, acquitted him of the assault with intent to rape charge, which suggests that the jury was capable of weighing the evidence properly without improperly considering propensity evidence or anything to that effect. So unless there are any questions on that topic, I'll move on to the Miranda issue. First and foremost, with the Miranda issue, there was no interrogation as to the first statement, and the motion judge erred in suppressing that statement. He found that the defendant was placed in the rear of the cruiser, and while sitting in the rear of the cruiser, he made this statement in response to questions for his identification. Booking questions are not identification. Are not interrogation questions. And in the reply brief, the defendant said, "Oh, but this is the functional equivalent of interrogation." And respectfully, if this is the functional equivalent of interrogation, then the distinction between custody without interrogation and custodial interrogation is meaningless. I will mention there's the infamous case Brewer versus Williams. That's the United States Supreme Court, 430 U.S. 387 from 1977, the infamous Christian burial speech case. That's the functional equivalent of interrogation. So there was no interrogation here. The judge should not have suppressed the first statement, which renders the question of cat out of the bag rather moot. Assuming that this court were to find that the judge properly suppressed the first statement, the cat still isn't out of the bag here because the statement, "I gave him a ride, but nothing happened," is not inculpatory. And with regard to Smyth versus Watkins, the Commonwealth does rely upon Watkins and also upon Rosa Roman, both of which statements the defendant made one statement and then made another statement a substantial amount of time later. And there's deemed in both cases to be a sufficient break that it's not a single continuous interrogation. In Watkins, the defendant made a statement that was technically incriminating in some respects, but at the time he made that statement, he knew it was incriminating. Whereas in Commonwealth versus Smyth, the defendant made a statement that the police knew to be a false statement and the defendant did not know it. He did not know that the police knew that, so he was not aware of how incriminating his initial statement actually was as far as the police's own knowledge. Whereas in Watkins, the defendant knew. Here we have Watkins, not Smyth. The defendant knew exactly how incriminating or not that statement was when he made it. So the cat was not out of the bag at the time of his later statement because his initial statement was entirely self-interested. Yes, as he says, I was with him, but absolutely nothing happened. If he had stuck to that story, he would never have incriminated himself. Whereas his later story that, oh, okay, we parked, but he was the one who initiated everything, that's a very different version. And frankly, that's not particularly incriminating either. He's spinning the story to his own advantage the entire time, so I would suggest that the cat's not out of the bag, assuming the first statement's improper in the first place, unless there are any questions.
Would you talk about if there was a break, if
Yes.
there were any intervening circumstances?
Well, it's in many respects, it's similar to Rosa Roman. The first statement is in the rear of a police cruiser. He's on the side of the road in location A. Then there's a break. He gets taken to the police station, different location. He is given the opportunity to make a phone call. He does not make it, but he is given the opportunity. Different officers speak to him. So there are multiple circumstances that actually change one to the other. The only distinction in that respect between this case and Rosa Roman is that in Rosa Roman, the conversation was actually initiated at the defendant's specific request, the later conversation, whereas here, the detective went to speak to the defendant and said, "I would like to speak to you," and the defendant agreed, apparently quite willingly. So this case is very similar to Rosa Roman, where a break was found to have happened. Unless there are any questions, that rest on the Commonwealth's brief.
Seeing none, thank you.
Thank you.
Thank you both. The next case on our hearing list is the first of two matters that are paired relating to the same property in Brookline, Massachusetts. Case number 2022 P1066 is the first of the two, BOYLSTON3 LLC and others versus Jonathan Richardson and others. So for the appellants, I see that you're dividing your time 12 minutes and 3 minutes. Who will be going first?
Thank you very much, Your Honor. Dr. Pence will be speaking first, but she woke up with a sore throat, so her voice may be a little off.
Okay. So she will have 3 minutes. We'll reset the clock. Okay.
Thank you, Your Honor. I'm sorry about my voice today. So the first of the things is that easements need to be written, and if they're written in a limited manner with language that's very specific, that language should be used to interpret those easements. Looking at the home, 619 Boylston and 617 Boylston, 619 Boylston's easement is that the easement is for access and egress to the garage as shown on the map versus utilities to the lot. And because...
So let me understand this, if I can just ask the question. If you're talking about access to the garage in a vehicle, I assume.
In a vehicle or by foot.
By foot, okay. And so, but presumably, if it's a vehicle, the vehicle is driven by a human being. If it's on foot, the human being is doing the walking. After the vehicle or the person gets to the garage, they're then to stay there? Is that the way it works?
Well, I mean, they would access the home, but it's...
Well, the home is not the garage.
Right.
Now I'm confused.
As long as they could access the garage, they would need to access the garage.
If they go into the home from the garage, are they then permitted to go out into the front yard?
Yes. Yes.
Yes. Or the backyard?
Yes.
Or the driveway?
the thing is, the easement as written is very limited, and I think...
You said that, but I'm just trying to understand
I think
the effect of what it is that you said, so that, is it correct that the person, after exiting the vehicle or after entering the garage on foot and going into the house, could go out and stand in the driveway or not?
Yes,
I thought so.
could, yeah. And
So the access to the garage carries with it, as ancillary, the opportunity to use it for access to the other portions of the property.
Yes, as long as the intention was to initially.
So I see that expends your 3 minutes. Let's hear from Mr. Murcia. Thank you.
Thank you very much, Your Honor. If I were to follow up on what Dr. Pense was saying, the ability to access other parts of the lot came from having had a bona fide reason to go to the garage. Whether the easement granted the right to go from the garage to other parts of the lot, I would say the easement did not specifically grant that. Certainly a license, as was created between the two brothers who divided the lots in 1982, did provide for that. But that was a license above and beyond the easement. My understanding of Massachusetts law of easements, I think they call it the, quote, bright line rule, that the specific property or area that benefits from an easement is the only area that actually has the easement to benefit from it.
Generally speaking, that proposition is true. Generally speaking, that description refers to the entire parcel of land, not to a discrete structure situated on that land. That's why we talk about the dominant estate and the servient estate.
Sure. So I don't know which PowerPoint you ultimately...
We have both.
You have
received
all
the
of
other
them.
one this morning, and we're able to download it to our iPads during the break.
That's very kind of you. If you look at page 15 of the second iPad, of the second PowerPoint, it's called V2, I think, 22P 1066. It's a total of 34 slides.
So page 15 we have.
It should look with the 1982 deed with some highlights.
Portions of the land courts.
The title of the slide should be Land Court Erred by Disregarding the Below Highlighted Limiting Words. So if you then move on to slide 16, first of all, in case the intent of the authors of the 1982 deed was simply to grant an easement to the entire lot, I think they would have ended with the parties shall have the to use the driveway as shown on the plan for all purposes, period. They would not have needed any of the subsequent words. They would not have needed to distinguish between access and egress between Boylston Street and the garage. They would not have gone on to say for utility services to the lots. These are additional words which I think had some meaning. The authors of the 1982 deed were both professors in medicine from Harvard Medical School, very well educated. The authors of the deed were attorneys at Ropes and Gray, who were also very skilled at drafting deeds. All of the additional language that they included in that paragraph 3B would be of no meaning whatsoever. And my understanding of Massachusetts law, and I can't cite the case, is that when words are included in a deed, the most comprehensive possible interpretation that takes into consideration the additional words is the interpretation that should stand.
What is the case that you would suggest to us offers the clearest comparable set of facts that would restrict the scope of rights in an easement to a specific structure on a lot?
For example, this court ruled in the case of Hamuda versus Harris, where it was an easement to a garage which had 2 bays in it. But that did not include ancillary parking spaces outside of that garage. Even after the garage was raised, this court found that it's still 2 parking spaces because those were the 2 parking spaces that benefited from the original easement, and the original easement grant was specific of what benefited.
Let me ask a somewhat different question. My recollection of the history of this easement and of these parcels is that at some point, the downhill lots, the Boylston frontage lots, surrendered their rights over that portion of the easement that are situated on the lot known as 619. Is that correct?
I don't believe so. I'm not sure what you mean by downhill, and I apologize.
What I mean by downhill is 617 and 615 on the one side and 621 and 623 on the other side.
If you look at page 22 on the iPad, it gives all of the relevant lots.
Right. That's where I am.
Okay.
So when I'm talking about downhill, I'm talking about 621, 617, 623, and 615, treating 619 as the one that's uphill. I'm familiar with this is right next to Fisher Hill, right? This is right next to Fisher Hill.
This is right next to Fisher Hill.
Yes, I'm familiar with the area.
Fantastic. So 617, 615, 621, 615, 621, and 7 Fisher Ave, they have a conservation easement on them, which limits construction.
No, I understand that, but my question was, my recollection is that at some point the owners of 617, 621, 615, and 623 surrendered.
And there was a release of use of the garage on 619, and that took place in 2014 when Lot 621 was born, in part from a Lot 2C and in part from a Lot 1C.
Right.
Okay. So I'll jump to slide 16. In slide 16, access and egress to the entirety of Lot 2 was broadly granted by paragraph 3A of the deed of 1982, where it says Catlin Road can just be used for any purposes. Doesn't go into any details of it. Similarly, Boylston Street, which Lot 2 fronted on and had over 100 feet of frontage on, could be used for any purpose. So those are 2 public roads which clearly made Lot 2 of the 1982 plan not landlocked. And this deed of 1982 made specific reference to the usability of both Catlin Road and Boylston Street, without limitations. It's only use of the driveway, which was primarily on on Lot 1 at the time, which they were very limited. And one might wonder why brothers would be limiting the easement. One, why are they writing all these extra words instead of just to pass and to repass, as they did in paragraph 3B of the 1982 deed? The other is, why do brothers enter into deeds or easements as opposed to just verbal licenses? And the reason is that one can persist. Properties may not always be owned by the people whom you expect would own the properties. If you go to page 13 of the PowerPoint on the iPad, this epitomizes why the brothers were so particular. Your Honor mentioned that you're familiar with Fisher Hill Estates, and this is in reference to page 13. Fisher Hill Estates was approved in 1981. In 1982, when these brothers signed this deed, Fisher Hill Estates would have been under construction or something like that. And Fisher Hill Estates took driveways that went to large estate homes on multiple acres, very similar to the homes at 617 and 619, and it turned those private driveways into thoroughfares. The home at 617 Boylston Street at the time was owned by Margaret Richardson, who donated substantial lands for conservation, wanted to preserve trees and the green appearance of the area. It stands to reason that she didn't want her home to become a thoroughfare for cars. Slide 13 shows what would happen if they didn't write paragraph 3B of the deed the way that they did. If they had ended paragraph 3B with just an easement to pass and to repass, then what you're seeing on slide 13 could happen. And that's actually a slide that was prepared by the architects of Appellee Boylston Brookline, Tice Design Associates. And there, the driveway on 617 literally becomes a thoroughfare, serving instead of 1, maybe 2 homes, 15 or 16 homes. As you'll see in subsequent slides, they recognize that
that would also have extended the easement rights to an additional parcel of land, which in common parlance is described as overburdening or overloading.
Fair enough. However, even on the land that was Lot 1, without overburdening or going beyond, Lot 1 was something like 90,000 square feet in an S15 zone where it's 15,000 square feet per home or per dwelling unit. 6 dwelling units could have been built on Lot 1 without overburdening the easement. If there's issues of frontage and vehicular access, at the very least, another 3 units could have been built on Lot 1 with the frontage which they had on Boylston Street and Catlin Road. So the brothers, as they divided the lots in 1982, both Harvard Medical School physicians, their attorneys at Ropes and Gray, they didn't end with just to pass and to repass. They were so specific about the rights to the use of the driveway, which was primarily on 617 Boylston. As you'll see, one of the children of one of the brothers, Edward Richardson III, the son of Edward Richardson, actually goes to great length to create an option for an easement over 25 Fisher Avenue so that the driveway from 25 Fisher Ave could come to the garage at 619 Boylston. In the 1950s, and I couldn't find the deed, but in the 1950s, the garage on 619 Boylston used to actually be the garage to Mr. Keogh's home at 25 Fisher Avenue. That garage was bought by the 2 brothers who divided 617 and 619 and then subsequently shared it. In short, the explicit language of the 1982 deed is such that it was not the intention to leave it as a broad easement. It was the intention to leave it specifically. They were brothers, so they gave each other license to do beyond that.
Thank you.
Good afternoon. May it please the court. My name is Don Gentile, and I represent Boylston Brookline LLC, which is the owner of 619 Boylston Street. Before I begin, I'd just like to note that I received a filing from the appellants at 1:30 this morning and another filing at 9:30 this morning as I sat here in court. It is impossible for me to prepare based on those materials. I scanned them, but it's a problem, and I ask that they be stricken from the appellate record.
Those were in the nature of chalks for the purpose of a visual aid in the presentation. We had previously indicated that we would allow Mr. Murcia to work in this presentation from a PowerPoint. They are not part of the record. They simply incorporate record materials. I understand that you received them very lately, but I would suggest to you will not significantly affect your ability to respond if you know the case.
Thank you, Your Honor. My client purchased the property on May 26, 2022 from Jonathan and Dorothy Richardson, who were the litigants in the land court case. My client has an appurtenant easement to use the shared driveway at issue for all purposes of access and egress from its property. The grant of this easement is unambiguous and originally derived from 2 documents, the 1981 deed and the 1981 plan, which is referenced in the 1982 deed. As you know, the 1982 deed was then entered into between the Richardson brothers, who at that time owned all the property abutting the shared driveway. The 1982 deed stated, "Parties shall have the right to use the driveway as shown on the plan for all purposes of access and egress between Boylston Street and the garage." And it went on to remove doubt by further explaining that broad grant of easement. Contrary to what the appellant stated, those extra words, if you will, were not needless. They did not restrict the easement, but they were qualifying words to remove doubt in order to do the opposite of what the appellant has argued, in order to grant the most broad easement available. That 1982 deed has been referenced repeatedly in the chain of title, in the subdivision documents as the chain of title progresses, and was listed extensively in the appellant's deed itself.
Well, as you know, it wouldn't matter one way or the other if it was repeated in the subsequent instruments of conveyance, right? By statute, the rights once established would pass with the title.
That's absolutely correct, Your Honor.
That respect being that in 1982, the garage at the end of the driveway was shared by the two property owners, who happened to be related as brothers.
Under the terms, it was shared.
Yeah.
That being said, under settled...
So that the purpose of the use of the garage was to serve two different residences on different lots, right? One on 619 and the other on, I don't remember the history, whether it was 623 or 617.
At the time, it was shared by the owners, yes, Your Honor.
So the driveway, the garage at the terminus of the driveway was located on the lot for 619 and served that residence on 619, but it also was being used for vehicular storage for a residence on a different lot.
Yes, Your Honor.
Okay. And that's no longer the case now that the garage is serving solely the residence on 619?
That's true, and that also goes to your prior point of the 2014 deed, where certain rights were relinquished. And I think Hamuda is illustrative, because when you compare it to this case, it's very different. And the appellants rely on that case almost exclusively. Under settled Massachusetts precedent, the words contained in the easement at bar state for all purposes of access and egress. And under settled Massachusetts law, as you know, that includes a general grant for every reasonable use to which the dominant estate may be devoted, which may vary from time to time with what is necessary to constitute full enjoyment of the premises. And I quote from Mahon versus Tully, SJC case 1923. The grant of easement in Hamuda, on the other hand, was completely different. It's apples and oranges. That grant of easement was very specific as to point A to point B. And that's why that case is not controlling here. I would also like to point out that you are dealing with an excellent land court decision. It's well-researched, it's well-written.
Some would say that's redundant.
It's well-reasoned, and it's an excellent decision. And the land court goes one step further, as you know, and analyzes this case in the alternative. So our position is that this deed is absolutely unambiguous, and that was the position of the land court. But the land court goes one step further and rules, even if ambiguous, this easement also grants a full, broad easement for 619 Boylston Street under the attendant facts. So Your Honors, in the very unlikely event that you found this was ambiguous, I couldn't envision that, but if you did, you also have a very well-reasoned decision from the land court on the alternative analysis in this case. And if there are no further questions, I will rest on my brief. Thank you.
Thank you. Mr. Keough, is it?
It is. Good afternoon, Chief Justice Green, Justice Smith, Justice Walsh. My name is John Keough. I represent the appellee, John Keough, as trustee of the Fisher Hill Realty Trust. In the land court, the Keough's interests were represented by Julia Davison. It was my co-counsel for the appeal. Ms. Davison could not be here today due to a schedule conflict, but in any event, we had made the decision that for purposes of this oral argument, I was going to present the Keough position. Before I get to the merits, I had two brief comments on the additional filings that were made by the appellants early this morning and at about 9:30, as were referred to by Attorney Gentile. There is a suggestion in those materials that at one point there is or was an easement from Fisher Avenue that connected to the 621 lot, and I don't think that's accurate. I don't think there is now or ever was such an easement.
Once again, those materials were solely an accommodation to allow Mr. Murcia to make his presentation utilizing the PowerPoint tool. They do not reflect any additional new argument other than what was presented here this morning.
Okay. All right. My other comment was in the PowerPoint presentation that was allowed by this court, there are quotation marks that are attributed to the Krinsky versus Hoffman case, and I do not believe those quotation marks are accurate. I've searched that case, and I don't see the language that's quoted in the PowerPoint does not appear to exist in the case.
You can rely on the panel to identify accurate citations and language from the cases.
And one further matter, about a year ago, Ms. Davison filed a motion to dismiss Mr. Murcia from this case for the reason that he had no standing. The argument was and is that Mr. Murcia was not a party to the land court case. He was not an owner of record at the relevant time. He's not named as a party in either the complaint or the amended complaint that was filed. He had a habit of filing papers, inserting himself into the caption, much as he's done in this appeal. And the papers were stricken. Judge Rubin ruled that he wasn't a party, and yet he continued to file things, and that same behavior has occurred in this case. And we warned this court a year ago that if Mr. Murcia were allowed to stay in the case, it would lead to confusion, delay, frivolous arguments, and
With due respect, we're not confused.
Well, the challenge in writing a brief in this case was twofold. Number one, it was to discern precisely what the appellants were saying, and the second challenge was to improve upon what was a very thorough opinion from Judge Rubin in the land court. It's hard to say it better than it was said by the land court, but briefly, with regard to the easement, Judge Rubin found that there was language in the deeds themselves referencing this driveway easement that was created, and that language created an express easement. In addition to the language in the deeds, every deed to every parcel of the so-called 4 square parcels, that is the lower parcels that Chief Justice Green referred to, every single one of those deeds refers to a recorded plan that shows the common driveway graphically, but each of those plans has a note section, and each of those note sections has express language that says access is provided to to each of the 4 lots, actually 5 lots when you include 619. Access is provided to each of those lots over the driveway. That's express language that is incorporated into every deed as if it were set forth in the deed, and that also creates an express easement. Judge Rubin also went on to analyze this in the case of the express language weren't enough. She also found that there was an implied easement for much the same reason that she found an express easement. Indeed, it would be hard for the drafters to have had been more express or explicit in creating the easements that are for the benefit of all 4 lots. And the question, in addition to that, both the 619 parcel and the Keogh parcels had a count in the lower court where we asked for a ruling that all parties with deeded access to the driveway were responsible jointly for the upkeep, the cost of repair and maintenance, and Judge Rubin allowed that claim. That claim has not been appealed, but I would point out that the position of the appellants seems to be that everyone, all the owners, must jointly pay for the maintenance and expense of the common driveway, but only the appellants have the unfettered use of that driveway, and that would be an absurd result. Finally, I'll just briefly refer to the second issue. The appellants claim a right to park on a cobblestone parking area that is located entirely on the 621 parcel. And the only justification for that claim was an allegation that that a broker demonstrated to them that they were able to park there.
Right. Thank you. That brings us to the 6th and final case on this morning's list, again, including Mr. Keogh. Mr. Murcia is arguing the first 14 minutes, I understand, followed by Dr. Penzi for 1 minute.
Thank you very much, Your Honor. The 2 cases are intertwined, so I will respectfully both address some of the statements which they made, which relate to the second.
We're talking about the title claim on the 621 lot, as I understand it in this case.
Okay. With regards to Your Honor's question of cases that I have the same PowerPoint deck for both of them, because the relevant case law and the facts are similar.
Please confine your argument in this presentation to the issues arising in the title case on 621.
I will try my best to do so. Please ignore things that I say that are incorrect. I'm not trying to be difficult. Slide 5 in my 34-page PowerPoint refers to the case of Spencer versus Rabideau. This is a SJC Supreme Judicial Court case in 340 Mass 91, where the issue was a driveway which, instead of curving, was split between 2 lots, between 2 brothers, and then ultimately the 2 brothers were not the owners of it, and the SJC ultimately ruled that use was by permission and hence revocable. And I think that's actually probably the best case, as it deals with uses which are revocable. How that relates to 621 Boylston. So 621 Boylston, I'm not sure there was any use by 621 Boylston or the properties that Mr. Keogh has purportedly purchased. because those are vacant lots which have well-defined walking paths on them. If I go to the PowerPoint and make it so we can walk through that, I'll talk through the relevant slides from that. So the first slide of interest would be slide number 12, and slide number, slide number 23. I'm going to do this slowly. I'll use my time. I apologize for jumping around, Your Honor. Slide number 12 gives the general layout of 617, 619, the garage, Keogh's home, and the space between Keogh's home, which you see at the lower left-hand corner of that, and 617 Boylston Street, is what makes up 621 Boylston Street and 623 Boylston Street, which is the question of whether or not those areas have rights to the driveway. Now, insofar as the document that is supposed to form the rights of different properties to the driveway, it all goes back to everybody referring to the 1982 deed as the dominant deed. The challenge is that in 1982, if you look at slide 14, all of that was Lot 1. In 1982, the left side of the driveway on Lot 1 did not and could not have an easement over the right side of Lot 1. And when the left side of the driveway, which is roughly what Mr. Keogh represents, was conveyed, no easement was made over the right side of the driveway.
Circumstances ordinarily, an easement arises by implication when on the severance of the two lots.
The case of Krinsky versus Hoffman is very telling in that. The case of Krinsky versus Hoffman, I'm going to use my hands here. If this is, I believe, Mass Ave, there is one home here of Krinsky, one home here of Hoffman. And there is a driveway right in the middle between the two of them. A passageway, I think they called it in that specific case. These two were once upon a time in the 1800s owned by the same person. Then they conveyed one of the two parcels to another, but when they conveyed it, they retained an easement to use half of that passageway. All was well. Then, at some point in the early 1900s, both parcels were owned by the same person. And the SJC ruled in that case that as soon as the parcels were owned by the same person, the easement over that driveway in the middle evaporated. It was extinguished.
That's the opposite of what took place here.
I understand that. This gives the extreme example of even when there was an easement in the past, it gets extinguished. Once that easement was extinguished, and all of these were owned by the same person, the owner of both sides and the driveway in the middle sold one of the sides. When he sold it, he explicitly granted an easement to the buyer to use his half of the driveway. But he did not explicitly retain an easement for himself, the seller, to use a part of the driveway that was now on the buyer's, the grantee's land. And the SJC found that we will grant easements by necessity more easily to the grantee than the grantor. The grantor in this case failed to record an easement for his benefit, and consequently, no easement exists. The grantor may not use the half of the driveway that went to the grantee, but the grantee may use half of the driveway that stayed with the grantor. With regards to, quote, absurdity of people being responsible for maintaining driveways that they themselves do not have a right to, if you look at the bottom 4 lines of paragraph 3B of the 1982 deed, It expressly and explicitly says that the owners of Lot 1 would have to share in 1982 with maintenance of the circular loop of the driveway that serviced the home on Lot 1, 617, even though they had no rights to use that circular loop of driveway. If you look at the explicit reservation to create an easement on Mr. Keogh's deed of 2004, where he took possession of 25 Fisher Avenue, which is in the documents which I judicially noticed to the court, albeit late, and I apologize for my computer hack a couple of weeks ago. Even there, they expressly stated that even though he wouldn't have a use of this easement, which would go on to benefit part of 621 and 619 Boylston, he would still be responsible for maintaining and repairing that driveway on his 25 Fisher Ave that he didn't even need to use. The idea of, quote, absurdity, the bottom line is the deal is whatever people negotiate. The bottom line is the contract or the agreement is what two mutually consenting, capable parties agree to. Just as in the case of Spencer versus the one with the brothers, I'm sorry. In the case of Spencer versus Rabideau, the brothers in, I think, 1930s, they reached an agreement, and that agreement bound them as to what was shared and what wasn't shared and what they allowed to verbally let the other person do. And the verbal allowances are just licenses which may be revoked. Even when there's absurdity, and to be quite honest with you, from my common sense, the case of Krinsky versus Hoffman totally goes against anything that I would consider reasonable, that here you own both sides and the driveway, you sell one side, and the grantor still needs to use half of the driveway, and you say no. And you say it's because the grantor failed to retain the rights themselves. And that's what the case law is in Massachusetts. Unless we're rewriting SJC case law, I think I'm stuck with it, and unfortunately for Mr. Keogh, he's also stuck with it. But that's for you to decide, Your Honor, obviously. I don't mean to usurp your authority or your wisdom, and I'm not a lawyer and I'm not an expert on this stuff, so please forgive me if I've overspoken. With regards to my being a party to this case, you know, I'm a dumb simpleton doc. The court wrote in its docket, the cases are consolidated, and I quote, for all purposes. There was no further, whether you call it qualifying language, as Mr. Gentile said, or limiting language, as I've argued. There was no subsequent language. It just said the two cases are consolidated for all purposes. And I took that to mean I was a party to both cases and subsequently filed things. Only much later was I told I missed some deadline by which I had to express my being a party to the 619 driveway case, 340. I took at face value the court writing consolidated for all purposes. You know, the amazing thing about the courts and the clerks whom I've interacted with at this court and also at some other courts is increasingly courts seem kind, and certainly you've been very kind to accept my chalks and my late PowerPoints, that everybody is not a lawyer, everybody doesn't have the cash on hand to hire lawyers, but people should have a right to still have due process of law and justice. And part of that, my fifth grade elementary school education led me to believe that when something is, quote, consolidated for all purposes and nothing beyond that is written, that I could take it that I was a party to the case. And that would have also impacted the arguments in land court. So I've talked about Krinsky versus Hoffman. I've talked about Spencer versus Rabideau. Jumping to that slide which I'd mentioned early on, with the walkways on 621 Boylston Street, which is slide number 23 out of 34. So the lower two lots, or the lower three lots on this, 615, 623, and 7 Fisher Ave, are all conservation lots. 621, which doesn't have a conservation restriction, is maintained as a garden. And it has been for time immemorial. And so much so that if you look at these small gray lines, there are walking paths all over 623 and 7 Fisher Ave so that people can walk to 621 Boylston. There are granite steps that weigh far more than I could ever lift or imagine to move, bigger and wider than this podium, that go from Boylston Street up to 623 Boylston Street. And in the judicial notice, there's some Google photos which point out those walking paths with the steps on them. 621, for its use at the time of the grant, had and still has ample right-of-way. 621, the only reason Attorney Keogh purchased it, and Attorney Keogh is in the land court dealing with distressed properties, was because he knew he could access it from his home at 25 Fisher Avenue, and he had given 25 Fisher Hill Realty Trust in 2004 via a judicially noticed deed the right to actually build a driveway across his 25 Fisher Ave so that they could get to what is now in part 621 Boylston Street. Whether he remembers it or not, if you look at the judicially noticed items, it is there. It is with the Norfolk Registry of Deeds. He declared a homestead subsequent to the recording of that deed there. Thank you very much, Your Honor. I appreciate it.
And 1 minute for Dr. Pensy.
I just wanted to address the issue of the cobblestone pathway. So the cobblestone area, as per the lawyers of Mr. Keogh, had shown that part of the cobblestone to be part of the driveway, the shared driveway, and it has been used for the purposes, because there were no other homes, it has always been used for the benefit of 617. And if you look at at slide 29, it's actually, and that's by their attorneys, it's marked in yellow as being part of the shared driveway, that cobblestone area. And the purchase and sale gives rights to the shared driveway.
Okay, thank you. Mr. Keogh.
Thank you. May it please the court. My name is John Keogh on behalf of John Keogh, trustee of the Fisher Hill Realty Trust. I think the arguments that were just made by Mr. Murcia and Ms. Pense all relate to the prior case. Those all relate to the 320 land court case or the 1066 appeals court case. They go to the easement. The issues in this case, the 1065 appeal case, which is what we referred to as the 190 case in the land court, are totally different. There were 4 claims at issue in the 190 land court case. Keogh brought a claim for a declaratory judgment, seeking a declaratory judgment that a PDF copy of a deed that was filed by Mr. Murcia some 4 or 5 months after it was been signed and sent to him was null and void. The reason that Keogh made that claim was to clear title, because this deed, this copy of a deed that had been recorded, created a cloud on title. Now, the deed, Mr. Machia came to possession of a copy of the deed because the seller, Margaret Richardson's true trusting attorney, sent in an email prior to the scheduled closing, which attached a copy of the deed signed by Margaret Richardson to show that she was ready, willing and able to proceed. He did this, as his affidavit states, because it was his custom and practice to do so to show the other side that he was prepared to close.
My understanding of the circumstances of that exchange also was that it was designed to establish a position that if Mr. Machia did not tender the purchase price, that he would be in breach of the contract, and was to demonstrate that she was ready, willing, and able to close.
Yes, exactly.
It wasn't simply a matter of ordinary custom. It's not necessarily routine to send a copy of a signed deed prior to the closing. It's quite typical to send a copy of the proposed deed that will be signed and delivered at the closing, so that if there are any questions about its form, they can be resolved prior to the meeting of the parties at the closing itself. I mean, these things take all different shapes and sizes, but in the circumstances of this case, the deed signed was provided for the purpose of establishing a position that would support a claim of breach if Mr. Machia didn't tender the purchase price. Because there were already indications that the deal was not going to go forward, and this was anticipatory to litigation.
Yes, Your Honor. And then this copy of the deed, after Keogh purchased these same properties, several months later.
By Keogh, you mean yourself, right?
I do.
Just to be clear, I mean, you can use
somewhat
the first
awkward,
person.
although I'm in a representative capacity
As
as
trustee
of a realty trust. But some months after I purchased the properties, this PDF copy of a deed was recorded because electronic recording.
Judge Rubin ruled that the deed did not effect a transfer title for, among other reasons, that it was not delivered in the legal sense because there was no intent to effect delivery, and delivery is a question of intent.
Yes. But in the land court, Mr. Machia's position was he owned the property. That's what this case was about. This case was about title to the property. Mr. Machia claimed that deed gave him ownership to the property. The other actual claims in the land court in this case were a counterclaim by Mr. Machia where he claimed tortious interference with contract. He also requested specific performance of his purchase and sale with Margaret Richardson. And finally, there was a claim involving trespass, where Mr. Machia claimed that my children had trespassed by taking waste barrels across the common driveway on one instance and putting them in his property, and when he complained, I had them take the barrels back. Those were the actual claims, and they appeared to be, in the brief, he appears to be contesting the land court's dismissal of those claims. So I'll briefly address what were the actual issues.
Remind me, I read this case a while ago. There was some interdepartmental procedural activity under Chapter 211B, Section 9, and Trial Court Rule 12 to deal with the fact that certain of these claims do not fall within the land court's jurisdiction.
Yes.
That ultimately come to rest. Were these dismissed on jurisdictional grounds or on substantive grounds?
These claims were dismissed on substantive grounds. The tortious interference claim was dismissed because it was a claim for damages, and Judge Rubin found that she didn't have jurisdiction.
That's jurisdictional. That's
and she declined ancillary jurisdiction.
So that did not get brought in to the land court action by designation under 211B, Section 9.
It did not.
Okay.
And I would add that there is the same claim is pending in the federal court. Mr. Machia is a plaintiff in a
Which was the prior pending action? The federal court? Was this the first of those two actions or the federal court?
No, this is another action. This is
So I
a
understand,
further
but-
action that was filed more recently. It was
Which
filed
was
about a
first
year
in
ago.
time? The federal court action? Federal court action was first in time?
No, I think, Your Honor, you're confusing the federal court action with the superior court action. There's a superior court action between Mr. Machia and Margaret Richardson over breach of contract. That was filed after the 190 case in land court. I'm referring to another case in federal court that was filed about a year ago by Mr. Machia against me, Ned Richardson, and my wife claiming tortious interference with contract. That was filed a year ago. I haven't been served, but it's pending. So my point is, there is another case. If Mr. Machia wishes to pursue that claim, he has a case in federal court. His case for specific performance was dismissed for a number of reasons. The case was dismissed because of the pending Superior Court case. The Superior Court case between Mr. Machia and Margaret Richardson has since been resolved. There was a decision in July of 2023 in favor of Margaret Richardson on all counts. She prevailed on that. I don't believe a final judgment is entered, but a decision, I think the judge is just considering legal fees under 93A on that matter.
So we may still see that one.
I think that's highly likely. Highly likely. There was also a claim in the 190 land court case, as I mentioned, regarding trespass. Judge Rubin found that Mr. Machia was not an owner of the property at the time that claim was brought, so he didn't have standing to bring that claim. That has been appealed. It hasn't been argued here today, but he is appealing that and cites some cases in his brief, which...
I'm sorry, is that a separate action, or is that, isn't that within the judgment of this case?
Yes.
The case that's on appeal here?
That is within the 190 case, the trash barrel trespass claim. Judge Rubin found that Mr. Machia was not an owner, so he didn't have standing to bring that. She also found under a Latin phrase that I've forgotten that that the law does not concern itself with trifling matters, and she found that was a trifling matter. And I would urge the court to affirm on those grounds as well. In any event, Your Honor, the issues in the 190 case are separate from the easement case. And if I may jump quickly to the easement case, I think what the appellants in the easement case are really arguing is
We dealt with the easement case. Let's stick to the case that we have on the clock for this title question. We've identified the issue concerning delivery of the deed. We've identified the lack of subject matter jurisdiction for the land court over claims that properly lie in the Superior Court and, in fact, are pending in a separate action in the Superior Court. And we've got the trespass claim, which is within the land court's jurisdiction that Judge Rubin concluded was not sufficiently substantial to warrant judicial remedy. Is there anything more to say about this case?
Only that this case is the backdrop. This case, the facts of this case showed that Mr. Machia wanted to buy the so-called 621 properties. He had a purchase and sale to buy the properties. He had at the 11th hour, he informed the seller that he did not intend to go forward. He requested the return of his deposit. repeatedly. And then after I bought the property, I sent him an email. I sent Mr. Murcia, whom I had never met and didn't know, an email telling him that I had purchased the properties. And Mr. Murcia responded, "Congratulations. I look forward to getting to know you as well." And then several days later, he changed his tune and decided that he did want to purchase the properties. And then several months later, he decided he actually owned the properties. So that's the background for this. It's the reason that the rest of the litigation occurred. I mean, it's not only frivolous litigation. In my view, it's vexatious litigation. It's revenge litigation. It's litigation that Mr. Murcia has a long history of engaging in. In the Keogh motion to dismiss, we attached an exhibit of the 25 separate civil actions that Mr. Murcia has been involved in the last several years in various Massachusetts state and federal trial courts and appeals courts. That list of 25 cases has only grown. That was a year ago. The number is closer to 30 now. So that's the reason behind this litigation is it's vexatious. It's vexatious, and this is what Mr. Murcia does to his enemies who are real and perceived. For all of those reasons, Your Honor, I ask that the court affirm the decision from the Land Court in this 1065 appeal, and any other matters I would rely on the briefs. Thank you.
Thank you. Seeing no further questions from the panel, that will conclude the argument in this case, and the case is submitted. That also concludes the argument session today. Thank you to our court officer, to our session clerk who's handled the recording. This court is in recess.